May I leave to mention, my lord, item number 208 and 209 of monthly list. My lord, this is a simple matter. My lord, the caveaties have already accepted the speed post service. So, my lord, the deletion of publication is necessary. For that, the application has been made.
Direction for?
For deletion of, my lord, publication for service of citation.
So all the parties have given consent.
Not consent, they have accepted and received by speed post.
They have received by speed, but they have not come forward.
They are not.
No caveat lodged.
No caveat lodged.
Okay. Give day after tomorrow.
Tomorrow?
Has to be mentioned first.
May I permit to mention one matter? Item number 63, my lord. My other side is here, my lord. On 7th, my lord, you will allow the amendment application without sending the file, my lord. Main matter is in the list, my lord. Without, my lord, sending the file, my lord, to the department.
What is the amendment was?
My lord, one of the beneficiaries or died, my lord. His date of death is recorded, and my lord, his legal years are brought in record, my lord.
67.
It's 63, my lord.
Lord, she was hearing this that in the goods of Montu Devi Benia. Now, death was recorded. Unless the file goes down to the department, the amendment could not be carried out. So those,
Okay.
that has to be done by my lord's office.
And my lord, fix the date.
Amendment.
Let the amendment.
Let the amendment be done. My lord, may I have my lord's leave to mention one matter, my lord. This is the last order passed. I'm mentioning upon notice. This is the last order passed by Lordship. The testamentary proceeding, here, my lordship had fixed the matter on 18th. On 18th August at 2 p.m. Now, my lord, we are facing a difficulty. Another suit between the same brothers, the order of Supreme Court for day-to-day hearing. Not a day-to-day, but early hearing of Supreme Court. So Justice Saraf has fixed the matter on the same day. So the witness may be present, but the counsels are the same. And we couldn't tell the other judge that because of Supreme Court order, because at the same time. So I'm requesting your lordship.
So this matter may be taken to this bench. So that the
No, that is a completely different. This is no.
I am releasing it, mentioned before the justice so that.
Not at all, not at all. This is a suit court. That is company matter. Only I'm because that is so heavy, so I'm putting prior that 18th, yes.
So it is not
to take up the matter on 18th. And any other day be fixed. Only the counsels are difficult. The same sets of counsels. Now, any other day or whatever, my lord. I'm putting on notice.
Not in the list, na? Other parties here.
I've given notice.
Given the notice.
Oh, wait a second.
Yes.
Lordship may put it on some other day.
Some other day.
Yes. Both sides, same sets of counsel. So they will have the same problem.
Lordship may record his submission that Supreme Court is directed.
DS number 2 of 2020.
Day to day.
VGA 4 of 2020. The matter is mentioned today by the learned counsel for the plaintiff in presence of the learned counsel for the defendant. Learned counsel for the plaintiff submitted. This court has fixed the matter on 18th August 2023 at 2 p.m. for further cross-examination of PW2. He submits that between the same parties, another matter is fixed before the other bench.
Coordinate bench.
Coordinate bench. For witness, and that is also witness.
No, it's the hearing. Argument.
For hearing. And in the said case, there is a direction of the Honorable Supreme Court, and as such, it is not possible for the learned counsel for the appearing parties to appear before this court on 18th August 2023 for examination of the witness.
Any day.
Counsel for the respective parties submit that instead of 18th August 2023, the matter can be fixed to other dates so that the plaintiff can examine the witness number. Witness number 2 can be cross-examined by the party. In view of this, counsel for the defendant, there is no objection. Full stop. In view of the submission made by the counsel for the respective parties, let the matter appear on 21st September 2023 at 12 noon instead of 18th August 2020.
Deeply obliged. mention notice. Like that. Oh, the order to di dijiye. Order to di dijiye. Leave you like.
My lord, I am appearing for the plaintiff, my lord. Your pursuant to lordship's last order of 17th of July, the conversion has taken place from the original side regular division to the commercial division. But however, my lord, I'm told that the statement of truth and the necessary corrections of the cause title by hand has to be carried out. So for which I am seeking an extension by 2 weeks, because your lordship had granted us 2 weeks within which we had to carry out all the formalities as per the Commercial Codes Act. So
It is not done.
it is not done because my client stays in Raipur, my lord. I'm told he could not communicate within time. That is why it cannot be filed at the present moment.
Yes, you are for the
And
defendant.
Yes, my lord, we have recently been engaged to appear on behalf of the defendant. My lord, since my lord, the compliances are yet to be completed, lordship would kindly keeps it after 2 or 3 weeks, my lord. In the meantime, we'll also take steps. But maybe
My
file the
lord,
vakalatnama in before your lordship or my lord in the department. I'm grateful, my lord.
Counsel for the respective parties are present. Counsel for the plaintiff submitted by an order dated 17 July 2023. The above suit has been transferred to this court. The above suit has been transferred to this court. And there was a direction upon the plaintiff for compliance of the provisions of the Commercial Court Act within 2 weeks. For the counsel for the plaintiff submitted, the plaintiff is residing at Raipur, and as such, the plaintiff requests for the 2 weeks time for compliance of the provisions of the Commercial Court Act. In view of the submission made by the counsel for the plaintiff, further 2 weeks is granted to the plaintiff for compliance of the provisions of the Commercial Court Act. Let the matter appear on 30th August.
my lord, I'm also seeking another indulgence from your lordship. The IA number GA3 of 2014, which I believe is also appearing along with the suit. In that, my lord, pursuant to the last order of the Honorable Court dated 20th of March 2014, my learned friend was directed to deposit the quantum of the bank guarantee amount in the highest interest bearing account. And we have been writing since a long time. Let them just indicate us what is the amount which has accrued at the present moment along with the interest.
I'm not aware of the order.
Because we have been writing, they have entered appearance long ago. There has been a change, I believe, pursuant to which my learned friend is now appearing before your lordship. But the matter is an old matter of 2013. That is why your lordship had allowed my prayer for conversion. All I'm seeking is let there be also a direction on the defendant concerned, because today they are appearing before your lordship.
Where's the order?
The order was dated 20th of March 2014, my lord. This was the order which was passed, pursuant to which they were directed. আমার কাছেই copy নেই।
2014.
Yes, 2014. এই পেয়েছি আমার কাছে একটা। My lord kindly comes to the penultimate paragraph at internal page number 2 of the order, where the direction is contained. I direct the defendant to keep the guaranteed amount in a separate interest-bearing account, that is to say, in a term deposit with a bank earning the highest rate of interest free from any lien upon intimation to the advocate on record for the plaintiff. Now, we have been writing them, and lastly, we have also written to them on 30. In July, in the month of July, I'm told, we had written to them, but there has been no correspondence from there in giving us the intimation.
Counsel for the plaintiff draws the attention of the order passed by this court dated 20th March 2014 in GA number 212 of 2014, wherein this court has directed the defendant to keep the bank guarantee amount in a separate interest-bearing account. Separate interest-bearing account. And to intimate the same to the advocate on record of the plaintiff. Full stop. Counsel for the plaintiff submits that the plaintiff has several times requested the defendant to inform about the compliance of the order dated 20th March 2014, but till date the defendant has not informed the same. Consider the submission made by the counsel for the plaintiff. The defendant is directed to inform the next date of hearing before this court whether the amount is deposited or
My
not.
lord, the amount was deposited.
What is the quantum?
What is the accrued interest quotient and what
To
is the
inform
present
the
amount?
learner advocate on record of the plaintiff with regard to the compliance of the order dated 20th March.
And what is the present status of
And
that?
what is the present status of the said amount
Grateful,
lying
much
in the
appreciated.
fixed deposit?
देखें ना हम यहाँ इधर
Give back them. Take back madam your take back your document.
Yes.
Next.
I'm. এটাই তো আমাদেরটা তো
Yes.
I am for the plaintiff, my lord. I made my submissions on the last occasion about this silk. Burgess silk and my lord, they are carrying on since 1980 and their adoption in 2019. Immediately thereafter, the suit was filed.
Yes, where is other side?
Your Lordship, we are appearing. Mr. Ghosh is also appearing in this
Huh?
matter. Your Lordship, Mr. Devnath Ghosh is also appearing in this matter. Your Lordship, I think they've not completed. I can take notes, Your Lordship, in the meantime.
Now, my lord, I had on the last occasion had also pointed out to your lordship the defense taken by them. It's twofold according to me, subject to correction. Number one is, my lord, that others are using. My lord, that does not entitle them. Firstly, that does not entitle them to use. And secondly, I had shown your lordship that whenever my client came to know about such user, they have raised objection, and my lord, the applications for registrations were, my lord, either withdrawn or, my lord, rejected. Now, I really, my lord, cannot run around, my lord, to know who is there, who is, my lord, copying. Whenever it has come to my knowledge, my lord, I have taken steps, and a number of steps have been taken. And this second one, my lord, if I have understood it correctly, is the question of disclaimer.
Yes.
Now, disclaimer, my lord, firstly, I have shown your lordship, my lord, that in all the registrations, disclaimer was not there. That is number one. In any event, such disclaimer, my lord, does not entitle them, my lord, to, or my lord, does not, my lord, prevent me, my lord, from claiming the right. My lord, in this connection, oh, acha. হ্যাঁ, অত আর খেয়াল থাকে না। দেখি একটা হচ্ছে হ্যান্ড ফুট মাউথ সেই নাকি? হ্যাঁ, স্কুল থেকেই তো আসে। অ্যাকচুয়ালি তো কভার হয়ে গেছে। চুপ লাগছে। বলে দিয়েছি। No, judgment. Oh, my lord, I understand there is a notes.
Yes, it is there.
Now kindly come to the notes once. My lord, kindly come to my lord first, serial number 4. AIR 1955, Supreme Court, page 558. My lord, kindly come to running page 43, my lord, paragraph 8. 55 Supreme Court.
Yes.
The third thing to note is that the avowed purpose of the section is not to confer any direct benefit on the rival traders or the general public, but to define the right of the proprietor under the registration. The registration of a trademark confers substantial advantages on its proprietor, as will appear from the sections grouped together in chapter 4 under the heading Effect of Registration. It is, however, a notorious fact that there is a tendency on the part of some proprietors to get the operation of their trademarks expanded beyond their legitimate bounds. An illustration of an attempt of this kind is to be found in such and such. Temptation has even led some proprietors to make an exaggerated claim to the exclusive use on the of parts or matters contained in their trademark, in spite of the fact that they had expressly disclaimed the exclusive use of those parts or matters. Reference may be made to Greers versus so-and-so, commonly called the banquet case. The real purpose of requiring a disclaimer is to define the right of the proprietor under the registration so as to minimize, even if it cannot wholly eliminate, the possibility of extravagant and unauthorized claims being made on the score of registration of the trademark. The last feature of the section is its proviso. That proviso preserves intact any right which the proprietor may otherwise under any other law have in relation to the mark or any part thereof. The disclaimer is only for the purpose of the act. It does not affect the right of the proprietor except such as arise out of registration. That is to say, the special advantages which the act gives to the proprietor by reason of the registration of his trademark do not extend to the parts or matters which he disclaims. In short, the disclaimed part or matter are not within the protection of the statute. The circumstances, however, does not mean that the proprietor's right, if any, with respect to those parts or matters would not be protected otherwise than under the Act. If the proprietor has acquired any right by long usure of those parts or matters in connection with goods manufactured or sold by him or otherwise in relation to his trade, he may, on proof of the necessary facts, prevent an infringement of his right by a passing of action or a prosecution under the Indian Penal Code. Disclaimer does not affect those rights in any way. Then, in view of the meaning and scope of Section 13 of the Trademarks Act 1940 and its underlying purposes as discussed above, we proceed to consider, etc. I need not, my lord, please, it goes into the facts.
Yes.
So, my lord, mere disclaimer, my lord, as held by the Supreme Court, yes,
Okay.
under the Act. But my right of, my lord, claiming
Long
an
way you're-
injunction, yes, for my lord infringement or for my lord passing off, my lord, that continues to remain. Ball 16. My lord, kindly come to the first judgment at page 8, my lord.
Yes.
My lord, our High Court, kindly come to page 24, my lord. Running page 24. The last paragraph, my lord, at page 24. It is true that distinctiveness of the mark may be lost by extensive piracy so that the mark becomes public juris. It was held in National Bill, reported in AS 71 Supreme Court that mere neglect to proceed against the infringer does not necessarily constitute abandonment if it is in respect of infringements which are not sufficient to affect the distinctiveness of the mark, even if the proprietor is aware of them. When neglect by the owner of the mark to challenge the infringement is alleged, the character and the extent of the trade carried on by the infringer and their position in the commercial world have to be reckoned in considering whether the registered proprietor has lost his mark by such neglect. To establish the plea of common use, the use by other persons should be shown to be substantial. In the present case, there is no evidence regarding the extent of the trade carried on by the alleged infringers or their respective position in the trade. If the proprietor of the mark is expected to pursue each and every insignificant infringer to save his mark, his business will come to a standstill, because there may be occasion when malicious persons, just to harass the proprietor, may use his mark by way of pinpricks. In answer to this allegation, the respondent number 1 in Joyce's supplementary affidavit stated that there was no whisper of this case, etc. But this is, my lord, what this honorable court held. Now, my lord, kindly come to the next judgment. May I hurriedly, my lord, show some of them, my lord. 2004-29 PTC page 435 at running page 28. On the same point, my lord, the Delhi View, kindly come to page 35. Paragraph 17. Learned counsel for the defendant has vehemently argued that the plaintiff is not entitled to this discretionary relief on account of its acquiescence and laches in objecting to the use of the trademark Reddy by the defendant company. It is submitted that since 1997, the plaintiff knew that the defendant is trading and functioning under the trade name Reddy, but it never objected, and to the contrary, it kept on having business dealings with the defendant and appointed him a Delcrader agent in April 2003. This plea of the defendant is also prima facie untenable for the reason that till August 2003, there was no clash of interest between the plaintiff and the defendant company. And in fact, the defendant was engaged in advancing and promoting the business of the plaintiff company by acting as its agent for the sale of bulk drugs. The threat came in August 2003 when the defendant introduced in the market its pharmaceutical preparations and thereby threatened the business interest of the plaintiff company. This move of the defendant was malafide on the face of it, as it was not manufacturing pharmaceutical preparations earlier, but now it was trying to market the pharmaceutical preparations manufactured by others under the trade name Reddy. Now here also, my lord, Lordship will look into their affidavit, my lord, according to me in vain. My lord, there is no whisper, my lord, that this adoption of silk is an honest adoption, or that they did not know that I am substantially in market since 1980 with silk. There is no whisper. সেটা তো 55 মানে সুপ্রিম কোর্টে পড়ে kindly come to page 48, my lord. সুপ্রিম কোর্টের পরে কে কি বলবে? দিল্লি হাইকোর্ট। My lord, kindly come to page 48. Kindly come to paragraph 7 at page 49.
Yes.
Paragraph 7. The defendant contested the suit. It was denied that the word perfect was registered as trademark. The defendant stated that the plaintiffs had been guilty of suppression of material fact in as much as it was never disclosed that at the time of registration of the trademark, Swastik perfect, there was a disclaimer by them in respect of the word perfect. They contended that the word perfect pertained to the quality of the article and that the same could not be registered as trademark at all. They also stated that the word perfect is being used by several manufacturers of stoves like SMI Perfect, Khash Perfect, Butterfly Perfect, Bijoy Perfect, Trishul Perfect, and so on. Their case is that they are not using the word Swastik or any of their stoves on any of their stoves, and that they are manufacturing and selling the stoves under the trademark Trishul Perfect and Bijoy Perfect. They admitted that they were stocking and selling the stoves manufactured by the plaintiff up to the year 1981, etc. Now kindly come to paragraph 10, my lord, at the bottom. First of all, I take up with respect to the alleged right of use of the trademark. Section 91D of the Trademark Act 1958 inter lays down that trademark shall not be registered of it has direct reference to the character and quality of the goods. In the present case, there is no manner of doubt that the word perfect describes the quality of the goods. The word is an adjective of a laudatory epithet. Under these circumstances, trademark in respect of the word perfect cannot be registered. Actually, also, there was no registration with respect to the word perfect. Section 17 of the said Act provides for disclaimer with respect to a particular word at the time of registration of trademark. Disclaimer means that the registration does not confer any right of exclusive use of a particular word in the trademark. In the present case, it is admitted case of the plaintiff, although not stated in the plaint but admitted in para 3 of the application, that the registration of the trademark Swastik Perfect was subject to the disclaimer of the word perfect. The net result, therefore, is that the plaintiffs do not have the exclusive right to use the word perfect on the basis of registration of the trademark. This was considered by the counsel for the plaintiff at the time of argument. The plaintiffs, however, laid great emphasis on the fact that on account of long usure, the plaintiff became the proprietor of even the word perfect in the trademark and therefore is entitled to restrain the defendant from passing off the goods as that of the plaintiffs by way of using the word perfect in the trademark of the latter. Therefore, it is to be seen if the plaintiffs are entitled to restrain the defendant from using the word perfect on the principle of passing off. The contention of the learned counsel for the defendant is that whenever there is disclaimer with respect to a particular word, no right to exclusive use with respect to that word can be acquired, and no action on the basis of principle of passing off can be brought. However, I am of the opinion that disclaimer does not in any way debar acquiring of a right to exclusive use of a word in the trademark otherwise than by registration, and the defendant can be restrained from passing off his goods as that of the plaintiff. In this respect, the proviso to Section 17 of the Trademark Act 1958 is very important, and the said proviso reads as follows. Then 12. The right against passing off does not arise out of registration of a trademark and is independent. This is clear from Section 27 of the Trade and Merchandise Act, which reads as under. Then, my lord, it is set out. Then kindly come to 13. The Registrar of Trademark versus such and such reported. This is the, my lord, 55 Supreme Court which I had placed.
Yes.
Then kindly come to paragraph 14. It is clear from the aforesaid observation that notwithstanding disclaimer or refusal to register a particular word in a trademark, passing of action, all action can be brought, and a trader can protect his right by way of such an action.
Yes.
18. Then, my lord, 15, 16, my lord, the cases, then kindly come to paragraph 18. Now, it is to be seen if the plaintiffs are entitled to an injunction on the basis of passing off. It is not disputed that the plaintiff has been using the word perfect as trademark, both as such and coupled with shosik. In para 7 of the plaintiff, it is stated by the plaintiffs that the trademark perfect is being used by them since the year 1964. This was not denied in the written statement, and it is merely stated that the plaintiffs are not the owners of the trademark perfect as alleged. At the time of argument, this fact was not controverted. It is further common ground between the parties that the defendant was stockist and selling agent of the stove manufacturer, etc. It is, next, my lord, after this Bijoy perfect in bold, it is therefore clear that the user of the trademark perfect by the plaintiff is much earlier than the user of the same by the defendant. It is also obvious that the defendant, being stockist and seller of the product of the plaintiff, can easily pass off his product as those of the plaintiff because of the same trademark perfect. Therefore, it is necessary to stop this said passing off and deceit.
Yes.
Yeah, 52 with last line the injunction into a on account of delay injunction for trade.
My lord, and my lord, paragraph 22. Kindly see the last 4 lines. I issue temporary injunction restraining the defendant from using the word perfect as a trademark or in the words denoting his trademark in respect of stoves manufactured by the defendant, and from passing off his stoves as that manufactured by the plaintiff. This injunction will
Injunction granted. Yes.
Irrespective of administration,
কোনটা দেখে বিয়ার
66 which is 79.
Now, my lord, kindly come to where I'm possibly repeating, but my lord, I'm trying to show, my lord, that this view of, my lord, old view has been consistently followed. And my lord, kindly come to, my lord, serial page number 79. My lord, the Supreme Court judgment of 2016. My lord, kindly come to the facts, paragraph 1, my lord.
Yes.
The respondent herein is a registered owner of trademark Ittukadai Halwa. Though this trademark got registered by the respondent plaintiff sometimes in the year 2007, as would be noted hereafter. According to the respondent plaintiff, the business of selling halwa in the aforesaid name was started by her father-in-law way back in the year 1900. When she found that the appellant was also selling halwa under the trade name Ittukadai Halwa, she filed suit for declaration, permanent injunction, and other reliefs on the ground that the appellant had adopted deceptive similar trademark to confuse the consumers. This suit was decreed by the trial court on such and such. Insofar as the relief of rendition of account is concerned, it was denied by the trial court. The appellant herein filed an appeal against the said decree before the High Court at Madras. The High Court had dismissed the appeal, thereby affirming the decree of the trial court with a judgment dated such and such. It is this judgment which is challenged by the appellant defendant in the present proceeding. Now, kindly come to Lord, kindly come to page, my lord, paragraph 22 continuation. Kindly come to page 86. At page 87, my lord. Continuation of paragraph 22.
Yes.
At the top, my lord. Section 34 of the Trademarks Act 1999 provides that nothing in this act shall entitle the registered proprietor or registered user to interfere with the right of prior user. Conjoint reading of section 34, 27, and 28 would show that the rights of registration are subject to section 34, which can be seen from the opening words of section 28 of the Act, which states, subject to other provisions of this Act, the registration of a trademark shall, if valid, give to the registered proprietor, etc. And also the opening words of section 34, which states, nothing in this Act shall entitle the proprietor of a registered user of a registered trademark to interfere. Thus, the scheme of the Act is such where right of prior user are recognized superior than that of the registration, and even the registered proprietor cannot disturb, interfere with the right of prior user. The overall effect of collective reading of the provisions of the Act is that the action for passing off, which is premised on the right of prior user generating a goodwill, shall be unaffected by any registration provided under the Act. This proposition has been discussed in extenso in the case of such and such, reported in AR 95 Delhi, wherein a division bench of Delhi High Court recognized that the registration is not an indivisible right and the same is subject to right of prior user. The said decision of HON'BLE was further affirmed by Supreme Court in such and such. The above were the reasoning from the provisions arising from the plain reading of the Act, which gives clear indication that the right of prior user are superior than that of registration and are unaffected by the registration rights under the Act. Secondly, there are other additional reasons as to why the passing of rights are considered to be superior than that of registration right. Traditionally, passing off in common law is considered to be a right for protection of goodwill in the business against misrepresentation caused in the course of trade and for prevention of resultant damage on account of the said misrepresentation. The three ingredients of passing off are goodwill, misrepresentation, and damage. These ingredients are considered to be classical trinity under the law of passing off, as per the speech of Lord Oliver laid down in the case of Reckitt Coleman versus such and such. which is more popularly known as Jeff Lemon case, wherein the Lord Oliver reduced the 5 guidelines laid out by Lord Diplock in such and such to 3 elements. Number 1, goodwill owned by a trader; 2, misrepresentation; and 3, damage to goodwill. Thus, the passing of action is essentially the action in deceit, where the common law rule is that no person is entitled to carry on his or her business on pretext that the said business is of that of another. This court has given its imprimatur to the above principle in the case of such and such, reported in year 2002. The applicability of the said principle can be seen as to which proprietor has generated the goodwill by way of use of the trademark in the trade name in the business. The use of the mark carrying on business under the name confers the right in favor of the person and generates goodwill in the market. Accordingly, the later user of the mark name or in the business cannot misrepresent his business as that of business of the prior right holder. This is the reason why essentially the prior user is considered to be superior than that of any other right. Consequently, the examination of right in common law, which are based on goodwill, misrepresentation, and damage, are independent of the registered right. The mere fact that both prior user and subsequent user are registered proprietors are irrelevant for the purpose of examining who generated the goodwill first in the market and whether the latter user is causing misrepresentation in the course of trade and damaging the goodwill and reputation of the prior right holder, former user. That is the additional reasoning that the statutory right must pave the way for common law right of passing off. Now, my lord, one further, my lord, to trouble your lordship, page 91. Right. 2 paragraphs, my lord, I shall rely on. Achha, very well. Kindly come to first, my lord, page 92.
Yes.
Well, at the submission at the top submits that being the registered proprietor of the word pro, the plaintiff has the exclusive right to use the mark. It is submitted that a registered trademark is infringed by a person if he uses the said mark without authority and in a manner which is likely to cause confusion on the part of the public. The absolute similarity or identity of the 2 marks are not required. The respondent is using the word mark pro in a highlighted manner with the suffix active just above the throat line on the tongue of a footwear, etc. Now, my lord, kindly come to paragraph 22. My lord, page 94, running page 94. A trademark is undoubtedly a visual device, but it is well-established law that the ascertainment of an essential feature is not to be by ocular taste alone. Since words can form part or indeed the whole of a mark, it is impossible to exclude consideration of the sound or significance of those words. Thus, it has long been accepted that if a word forming part of a mark has come in trade to use to identify the goods of the owner of the mark, it is an infringement of the mark itself to use that word as the mark or part of the mark of another trader, for confusion is likely to result. It is sufficient to refer to the word of Lord Justice so-and-so. If the goods of a manufacturer have, from the mark or device he has used, become known in the market by a particular name, I think that the adoption by a rival trader of any mark which will cause his goods to bear the same name in the market may be as much a violation of the right of that rival as the actual copy of the device. The likelihood of confusion or deception is in such cases is not disapproved by placing the two marks side by side and demonstrating how small is the chance of error in any customer who places his order for goods with both the mark clearly before him. For orders are not placed or
Under such conditions.
Or are often.
yes, or are often not placed under such conditions. It is more useful to observe that in most persons, the eye is not an accurate recorder of visual details, and that marks are remembered rather by general impression or by some significant detail than by any photographic recollection of the word.
When I see,
Yes, people go and ask for silk.
Any silk. If it is found the silk, silk. It is either the JSW or Asian.
People, my lord, so far as for 40 years or for 39 years, they have known silk to be Berger. Now kindly come to paragraph 27. In the instant case, the mark of the defendant is deceptively similar to the mark of the plaintiff. It is likely to create confusion. Moreover, it appears that the conjunction, moreover, it appears that the defendant has used fluorescent to highlight the word pro. The word active in conjunction with the word pro does not make much difference when the mark as a whole is considered. The defendant needs to explain the adoption of the word pro in its product, since the fact remains that the plaintiff is using the said work mark much before the defendant, inasmuch as the plaintiff is the registered owner of the word mark pro. In Midas, reported in 2004 Supreme Court, it was held that the law of the subject is well settled. In case of infringement either of trademark or of copyright, normally an injunction must flow. Mere delay in bringing action is not sufficient to defeat grant of injunction. In such cases, the grant of injunction also becomes necessary if it prima facie appears that the adoption of the mark was itself dishonest. But kindly take note of this, my lord. I'm sorry, my lord, at the cost of repetition, I would say that, my lord, they do not say that they did not know that I am carrying on business with the mark silk since 1980s.
No, their admitted case that they have came later on.
Much later, no, it could have been that, yes, I did not know.
No, it is not their case that they didn't know.
No.
This is not they had.
So it cannot be an honest adoption. It could have been anything, not silk. It could have been possibly, my lord, silk finish. Maybe, but not silk. Then, my lord, 28, in view of the aforesaid, I am of the prima facie view that the petitioner is entitled to an interim protection. আর কিছু ছেড়ে দেওয়ার দেখা না ডিলে তো নেই 2019 and my lord, as I said, my lord, I have shown your lordship on the last occasion the documents that they applied for, or my lord, they took steps in 2019 which says that they were yet to commence business. Suit was filed in 2020. Unfortunately, my lord, this pandemic and all this thing, my lord, today the application is for final hearing before your lordship. My lord, those are my respectful submissions.
Yes.
Your lordship,
শুরু
the
করো।
course will be
শুরু করো। তোমরা সব
Mr.
বলছো যে
Ghosh will be
পেন্ডিং
appearing in this matter, your lordship. Kindly keeps it, your lordship, next week, your lordship. A week starting from 21st, your lordship. Any. Means
How much time your
Lordship,
senior
please.
will take? Yes, Mr. Ghosh.
Any date, lordship, you say.
How much time you will take?
I'll at least will take an hour.
1 hour.
Have to distinguish his judgments also.
কিচ্ছু নেই, সব বাজে ঘুষি
Yes.
এতগুলো
মানে তো
11 judgments,
এতগুলো দেখাইনি
দেখাইনি দেখাই
or will 10 judgments.
এতগুলো দেখাইনি
not before that.
দেখি অ্যাপ্রিহেন্সিভ হচ্ছে
No, no. ছটা ছটা judge,
Only,
only 6.
only. Counsel for the respective parties are present. Full stop. Counsel for the plaintiff has concluded his argument. Full stop. Counsel for the defendant press for time. In view of the submission made by the counsel for the defendant, let the matter appear on, yes, 8 September. One date or two date? Two date continuous, so the matter can be,
8th and
otherwise again it will go if it is
8th
not
and 9th
completed.
will-
8 and 9?
My lord, 9th and 10th
সেপ্টেম্বর বলছে।
ও
Not August, September, after one.
না না
জজ সাহেব নেই, জজ সাহেবের অসুবিধা আছে, দেখি মানে অসুবিধা।
no after that can it be 11th and 12th or any other day?
11th and 12th September.
Lordship,
Both
I am
two
obliged.
dates I am fixing so that
I am obliged.
11th and 12th September.
শেষ কপি করে দিস, ওরা সফট কপি সেটা পাঠিয়ে
Yes.
I appear for the plaintiff search.
Yes, what is the review?
Yes, my lord, I would, my lord, we were on legs, my lord, we were indicating our submissions. My brief কোথায়? My brief টা দেখো না। Yes, my lord, lordship would recall, my lord, here my lord, I am appearing for the defendant. My lord, there was a distributorship agreement. Now, my lord, the distributorship agreement contained a clause that after termination of the agreement, my lord, it will be their obligation to take back the goods. Now, my lord, I had indicated to your lordship the clause that is there in the distributorship agreement. Lordship takes page 42 once. My lord, we had indicated to your lordship, my lord, clause 20A.
Rights and obligations.
Yes, my lord, it says that within 30 days after termination of this agreement, Fluid Power agrees to repurchase from the distributor, that is me, at the net price paid by the distributor plus actual transportation charges and import duties paid by the distributor thereon, any or all saleable products and parts held in stock by such and such, and distributor shall return to Fluid Power free of charge all such products and parts which Fluid Power has made available to the distributor free of charge. Now, my lord, evidently, my lord, the records, my lord, would indicate that, my lord, they had applied for judgment upon admission. My lord, that was, my lord, GA number, my lord, 971 of 2018, and my lord, they had obtained a decree against me. Now, my lord, the decree is dated September 2018. My lord, the decree is annexed to the review application. My lordship will find the decree, my lord, at, my lord, page 23 of the petition. Thereafter, my lord, the review petition was filed, but my lord, there is an order of this honorable court which says that I can press for the other prayers which are there in the review, even if I do not ask for or pray for review of the judgment or decree that was passed by this honorable court in terms whereof, my lord, my learned friend's application for order 12 rule 6 of the civil procedure code was allowed. My lord, there is no dispute in respect of that. Now, my lord, the issue is, my lord, even before, my lord, the termination of the agreement.
So what is the prayer in the review?
But here, my lord, first prayer was, my lord, for appointment of a special officer. Lordship would kindly ignore prayer A, that is for review.
Yes, you are not pressing that.
Yes, my lord, prayer C, my lord, which was for appointment of a special officer. My lord, that has already been allowed. My lord, by an order of 26th of November 2019, my lord, this honorable court had appointed a special officer directing the special officer to go to the concerned godown and make an inventory of the stocks which are lying there at. Malad, the special officer report is there on record. Now, Malad, prayer D is Malad is in the nature of a direction upon the respondent to immediate repurchase and take delivery of the entire unsold stock of power team products. Now, Malad, admittedly from the receiver's report and Malad, the inventory, Malad, it would be evident that all the goods that are lying at that area in the stock Malad, belongs to them. But I would only humbly beseech your lordship to take the affidavit in reply. Malad, the affidavit in reply contains the Malad, the receiver's report. We have annexed that.
Affidavit in reply.
Yes, affidavit in reply, Malad, it has been affirmed by one Naval Chajar on 8th of January 2020. But in fact, Malad, while allowing my prayer for appointment of a special officer, Malad, this honorable court, Malad, had considered Malad clause 20A of the distributorship agreement and held that it is an obligation on their part to take back the goods. Malad, first, Malad, I'll show your lordship the order. Kindly takes page 30 of my affidavit in reply. Page 30 of my affidavit in reply. The order dated 26th of November 2019 passed by this honorable court in this application.
Yes.
Yes, Manoj, I will not trouble your lordship with the entirety of the order. Kindly comes to page 31. The second paragraph at page 31. Manoj, kindly see. In the facts of the present case, it appears that there is an international distributorship agreement between the parties. Now, Manoj, clause 20A has been set out. Now, lordship kindly takes page 32. In terms of such clause of the international distributorship agreement, there is an obligation on the part of the plaintiff to repurchase the goods from the defendant on termination of the international distributorship agreement such and such. Now, no appeal from this order. They accept the finding of the learned judge that this is an obligation for them to repurchase the goods after termination. Now, there are emails disclosed in my affidavit in reply, which was before passing of the decree itself, that would show they have indicated their eagerness to take back the goods which are lying at the godown. Kindly takes page 48 onwards of the affidavit in reply. This is pre-passing of the decree. Decree is of September 18, 2019, 18th of September 2018. I'm sorry. This is an email of June 29, 2017. Kindly see the email. This is the email of the plaintiff. Kindly see what he writes to me. Kindly see the second paragraph of the email as a follow-up to the discussion. We SPX Flow are interested in investigating the further solution where, now kindly see paragraph B. JTC is me, Jain Trading Company. JTC compensate for the balance amount by means of transferring title of certain power team products in their inventory of SPX Flow goods. Subject to this transaction would be goods which have resale value to SPX Flow depending upon the type of condition evaluated at the original selling price by SPX Flow to JTC. They say that they will take back the goods provided they have a resale value. Now, kindly see towards the bottom of the page. After paragraph D of the email, actions to develop the discussion further. Kindly see serial number 2. Action to your team, that is my team, is to provide us with the list of power team goods in your current inventory with original purchase price for us to look through. It is anticipated we will have to schedule a visit to your premises to check the status of the goods once the short list is agreed upon. Now, trust we can progress from here quickly to a mutual satisfactory settlement of the current claims. Even before passing of the decree, they assured us that they will go to our godown and they will inventorize and they will see the goods and take back provided the goods have a resale value. Now, the special officer's report categorically concludes the special officer finds at the time of making inventory that all goods lying at the stock are sealed and in a complete packed situation. If it's a seal But if the tapes have not been opened, or if the boxes have not been opened, or the cartons have not been broken, I cannot tamper with the goods. Neither I can bring out the goods, nor I can distort any material or part of it. It's in sealed condition. So whatever was the value of the goods that the plaintiff had delivered to me, it remains the way it is. Now kindly comes to the next page, page 49. This is that subsequent email in the month of July 2017.
Yes.
First email Lordship will find of July 24, 2017, which is forwarding email, kindly comes to the middle of the page 49. This is an email of 20th of July 2017. This is very important. This is their email to me. Paragraph A, we note that the agreement reached in the meeting was for SPX to choose the products to take back from JTC's current inventory. The logic behind SPX may have broader opportunities to resell certain products than JTC, the precondition being the products to be of the type and the quality fit for resale. We note that we have forwarded a list with products of your choice. However, with the goal of maintaining the conversation going, we have gone through the list. Many of the products were purchased long time ago, dating back to 2005, which makes them non-suit for buying back. From your list, it would be possible for us to buy back up to US $20,000, which increases the cash payment to about US $180,000. Otherwise, please forward the full inventory list and we will look for goods of XPX flow, choice of such and such. But this is also an assurance on their part. And their stand that the only condition that they indicate that number one, the goods will have a resale value, and number two is that they should be their products. They want to check whether they are spurious or whether I have interpolated with their goods. This argument cannot be made at this stage. The reason being, these were issues of 2017. Now, subsequent that there was a decree. Now, the decree records many facts, but I am on this in the special officer's report.
What the degree says?
Decree, there was an admission on our part. On the basis of that admission, the learned court has, the honorable court has directed that I am liable to make payment of a sum of $160,708 US. That's a different aspect. I am on whatever goods, the goods or the stocks which are lying there at the go down, they should take back the goods because the agreement doesn't, because they in terms of clause 20A, and they should give price adjustment. Now, it's in the nature of a mandatory injunction.
In the suit, you have not filed the written statement.
Yes, written statement has been filed.
You have made out a counterclaim.
Yes, I have also made out a counterclaim.
What has happened to the counterclaim?
The suit is pending. The matter appeared. Lordship has
What is
directed.
the counterclaim in the suit?
Yes, I'll just indicate. But in the counterclaim, we had indicated each and every invoice that would match with the serial numbers
No,
of
that
the
is
goods.
correct, but what is the prayer in the counterclaim?
Yes, this will. Yes, we have prayed for that they should take immediately. It's a decree for mandatory injunction directing the plaintiff to repurchase and take delivery of the unsold stock. Now, I bow down, what's following from your lordship, that if this order is passed in the review application, this will technically amount to decreeing the suit or amounting the counterclaim. But in these cases, a mandatory injunction can be granted and an order of injunction in the nature of mandatory injunction can be granted, which will be akin to passing of a decree. Because this will close the issue. Because if lordship sees, it's on the basis, there cannot be any doubt that these.
But that can be done in a review application.
But it's not review. As on date, this is not review. There is an order of this court which says that I can press for the other prayers also. But I'll just show the order. Yes. I'm gonna kindly see the order. Dated October 10, 2018.
Yes.
Yes. But the review application was pending, was being adjudicated. Kindly see, this application shall not be treated as review and a substantive application for appointment of special officer and for other directions made in prayer C, D, E, and E of the petition. Now we will not pressing for prayer A and B, but my lord, there is a finding of this court that irrespective of the prayer of review, my lord, this application shall be treated as a substantive application in respect of appointment of special officer and for my lord, for the order that the direction should be given them to take back the goods.
No, so in other way, okay, this is cannot be taken as a substantive application for the review, but the court has appointed the special officer and the special
Yes.
officer has submitted the report.
Yes.
Whether they have taken the exception or not, that is different.
They have not taken any exception.
Taken if the report has come,
Yes.
so it would not be proper to go with the suit and take the report as some substantive evidence in the suit, and the decree can be claimed in the counterclaim.
Yes, may I say this? My lord, it was their submission on the last occasion that if I have not pressed for the review prayers, then my lord, whether I can maintain the ancillary reliefs, that is C, D, and E. My lord, this issue does not survive any further in view of the order of October 10, 2018.
Correct.
Now, my lord,
Only one thing, my lord, I must indicate because he is making his submissions. This issue survives because the order is an interlocutory order, which is not appealable. Till this application is decided, my claim that the application without the review petition memorandum of review is not maintainable, he has to answer. And after the adjudication means only then I can challenge that order. Because it's a commercial suit.
I'll answer this point. I answer this point. This point is not founded in their affidavit in opposition. No, it's not there. It's not there. His point is that if I have not pressed my review petition, by not pressing my review petition, the other ancillary reliefs claimed in the review petition will no longer be, cannot be maintained or argued.
See, what are the ancillary? First was your
Special officer.
Special, that
Yes.
has been done.
Yes.
Correct. With regard to the, you have accepted that this cannot be taken as a review application.
Yes, but I don't say that.
With regard
But
to
when we move the application, there is an order saying that this will be treated as a substantive application. That's a finding of the court.
Correct.
If my learned friend would have been aggrieved by this finding of the court, he should have preferred an appeal.
That's correct.
It may be an ad interim order, but an appeal from an ad interim order is maintainable.
It's a commercial suit, it's not maintainable. I can correct my learned friend.
No, that's correct. Whatever the argument, I will go through.
And this statement is being made from the bar. He cannot argue contrary to the foundation in the pleadings. Kindly see his affidavit in opposition. His affidavit in opposition is completely different, completely silent about this issue. Kindly see, the point is different. This is not the point that he has indicated in his affidavit. Yes, kindly take paragraph 4. Paragraph 3 and 4.
Where is AIU?
The affidavit in opposition of one Mr. Abhinandan Mahapatro.
Application. Have you filed the affidavit?
Yes, my lord, it's been filed. My lord, paragraph 3 also, my lord, I have taken the
in
point.
the court, but
I'm sure it has been filed.
or in the department.
Must have been in the department then, but we have served them a copy as well.
Yes, I have a copy.
My lord, lord should kindly see my copy.
Yes.
But kindly see page 3, paragraph 3. What is the averment? At the very outset, I say that the application is not maintainable in law or in the facts of the case. But this is a vague statement. The defendant has sought review of the judgment and decree dated in such and such in the said application. However, as is recorded in an order dated such and such, the defendant has sought to resile from pressing the review application. Now next, there are further prayers in the application seeking appointment of special officer and other prayers which have been made in the application which cannot be made in absence of a counterclaim and an adjudication thereupon at the stage of adjudication of the suit. What is he arguing is not there in the pleading. An argument cannot be made unless there is a foundation in the pleading.
The foundation is there.
No, it's not there.
Foundation is there that the
There
review
should be
is not
some clarity.
maintainable.
There should be some clarity. This is a vague
Foundation-
statement.
Okay. Let
Foundation
you
is
complete.
absolutely there. He cannot raise his voice and get on with it.
No, I'm not
Yes,
raising my voice.
Okay, you complete.
Let him make a submission. Suppose you don't have a case, you have to raise your voice.
But these statements are uncalled for. That I don't have a case.
Yes.
Yes. Now, Lordship would kindly take my application. 20 from April 2017. The situation was the distributorship agreement continued, and in the interregnum, they had written to distributors and my clients that they should not buy my goods. On one hand, on the basis of the admission, they apply for a decree, and on the other hand, they go and tell the market that I should not use their logo and I should not sell their goods. Kindly see the emails. It starts from page 100 onwards. First, Lordship, kindly, yes, page 100 onwards, Lordship, see.
Yes.
A series of emails between the exchange between the parties from 20th April 2017. This we write to them.
Yes, you already pointed out.
Yes. Now, something very important. Kindly comes to page 122 onwards.
One 122.
Yes.
Yes.
15th of September. Before that, Lordship kindly takes page 120 onwards. I'm sorry, 4th of September 2017. 4th of September 2017. This is their email. On the stock items, this is their email of 4th of September 2017. On the stock items you have identified, we can give you credit of 20,000 US dollars. If you would like SPX flow to consider up to 100,000 US dollars, please provide the list and we will look for goods of our interest. Per the discussion in the meeting in June, the choice of goods is with SPX flow. Clear admission on their part that they will take back the goods. Now next, please advise on the parts to take delivery from the order backlog file sent earlier. This is integral part of the tentative agreement discussed in June. JTC shall take US dollar 100,000 of the products they have ordered and pay via LC it should be. We need to know the specifics of the goods you will take delivery. Now this is their email of 4th of September 2017. Next, Lordship would kindly take our email. I'll show you, Lordship, their emails first. Page 122, 15th of September 2017. Kindly see, from the third paragraph. I will revert back to you as soon as practicable next week with the items of interest from the list you have submitted along with the buyback price. You and I will convene over the phone the target next week to come to a conclusion on the inventory buyback to credit versus the debt of 197,000 US dollars. One more email. Next, page 123. On 18th of September, page 123, this is their email. They write to us as a follow-up to our conversation on last Friday. Please find attached the goods. SPX may agree as a part of the settlement to buy back from your inventory. Subject to the goods being found in resellable and good conditions, total credit of the amount would be US dollars such and such. The goods are evaluated at the JTC buying price at the time the goods were purchased. In our opinion, this is the most fair methodology. Hope we can reach an agreement on this regard. I would like to get over the phone with you in such and such. September 2017 on September, June, July. Emails issued by the plaintiff wherein it has been recorded that they will come and take back the goods. On paper, assurance given that whatever may be the situation, they will come and take back the goods. And the special officer's report categorically indicates that the goods are in a sealed condition. That is number one. The inventory was conducted in the presence of the plaintiff's representative. There has been no objection at the time of making the inventory that the goods were spurious or interpolated, or the packs were broken or the seals were broken. No submission made until date. 2019 report, no exception filed till date.
Yes.
মোটামুটি cover করছি। My lordship kindly grant leave to Mr.
I don't want to repeat since he has covered the facts. I shall start from where he is ended. So he has shown, my lord, the documents by which they agreed to take back the goods. And especially what I would like to show is that the 4th September and the 15th September letter, which he has placed. In one letter, there's $100,000. In another,
Why you not press all the things at the time of passing order 12 rule 6?
There was no counterclaim.
There was no counterclaim. Exactly. That's us. There was no count. This is our money claim. So it was a change brief that had come. She filed the counterclaim immediately. Without because they have a administered amount. So against the admitted amount, decrease to be paid. Now lifting the goods is not a defense to the money decrease that is due and payable. Of course, they have not recovered anything. So now here is my counterclaim for recovery for return of the goods and for taking it back.
As per clause 20.
Now, lordship, factually, only thing I want to show before I come to the law is the order. Oh, no, this is Boshak's order. His lordship also found that in terms of such clause, page 32 of the.
Yes,
Yes.
That has been.
So, well, I am asking for taking back the goods. And yes, so taking back the goods, or I'm giving the price of the goods is on the rate which I mentioned in the petition. Of course, I'm asking for a mandatory order. And I will satisfy my lord that this is a case where mandatory order can be passed.
No, that's why I put the question to Mr. Basu. See, initially the suit was filed, preliminary decree was passed under order 12 rule 6 on consent judgment on admission. Subsequently, you filed the counterclaim. Now you have filed the review application. One of the orders said that it cannot be treated as.
No, I'm not going to review.
We go to the substantial application.
Substantial.
And a special officer was appointed, and a special officer has filed the report in your favor, whatever it may be. Admittedly, the goods are lying in the sealed pack.
My custody.
Correct. Admittedly, clause 20A is in your favor. Now, the only question whether in this application the order can be passed
Or suit hearing.
or in the suit, because in the suit there is a counterclaim.
There's a.
Counterclaim.
No, my lord, this application is the aid of the counterclaim. Counterclaim is as good as a suit.
No, but the counterclaim, you are having a separate, having a prayer claiming that. So that's why this cannot be taken in the suit, and you can take the benefit of the report of the commissioner.
Now, my lord, the reasons why
proceed
I'm
with the counterclaim.
the reasons why I am really seeking why I want an interim order is this application is filed in 2018 for reasons it could not be heard. Now, my lord, let's go back to 2018. My lord, in case I can get the order today for return of the goods, then I can show this as a defense under order 21 rule 33 of CPC and resist the execution, because this is a very unfair situation where I am saddled with $4 million worth of goods which they are supposed to take back.
So you are in troubling in the execution in connection with the judgment on admission.
That they have gone there. That's the whole difficulty. But so if now they will, my house, my property, everything will be sold, and then where probably even the godown will be gone. Where will the goods be? Well, the goods, and also the other aspect. Now the value of the goods. Of course, that's not my concern, but it'll have an impact. The more, because 18 when I came, the report was there. It was the value of the goods would have been worth more, because everything is not perishable really, but then it declines in value. That's why I will show the judgments where they say when there are in aid of a final decree for return or for taking back the goods, the courts can, and courts very often pass an order when there is really no defense on merits, that take back the goods or sell the goods or final reliefs can be granted. But this is a case where I would personally feel, because this is an inequitable situation. When my house will be sold, probably this godown will be sold. And for this recovery of money, while I shall be left with the goods, where will I keep them? I don't know. And Lordship also kindly know this is in this application at the ad interim stage, a receiver was appointed. They did not go up in appeal from that order. They accepted that order. That order was in aid of the final. That order was in aid of the final relief which I am praying in the interim application. The interim application, the final relief that I am praying, because this is an interim order. Interim order is in aid of the final order. I must say ad interim order. In aid of the final order, I am praying in the application. They accepted that order. So what is the purpose? So what I'm asking myself this question. Well, at the ad interim stage, a receiver is appointed to make an inventory. Inventory is done in the presence of their advocate. They don't even take an exception under the original side rules, which they could have taken if they wanted to take exception within 15 days.
No, they have not done so.
They haven't done that. So this report is sacrosanct. At the final hearing of the application, they take the point that this inventory report or the ad interim stage was really will serve the purpose. But that's why, well, I want to show the law here with facts. Facts, he has shown everything, so I will not trouble my lord with the facts. But on this is a fit case where I will seek a mandatory order. Otherwise, it will be a grossly inequitable situation. And may I start with chapter? Very well. They've taken an exception. I'm not troubling my lord. May I start with the judgment of our High Court, which has been reversed in Supreme Court on a different issue, not on this aspect. I will show I've got the Supreme Court also. This is reported in 2014, Volume 3, Calcutta Law Times. Page 510.
Yes.
From paragraph 57. There is no rule of law which prevents the court from granting interim relief on an interlocutory application, although the same might amount to granting the final relief claim. Paragraph 57. That is page 18 of 25. At the bottom, page 18 of 25. Paragraph 57.
Yes. 57.
There is no rule of law which prevents the court from granting relief on an interlocutory application, although the same might amount to granting the final relief claim. This is our case. Final relief claim, because a counterclaim is a suit. A mandatory injunction may be granted even at an interlocutory stage if the situation so demands. In the case of Woodford versus Smith, this is McGarry observed as follows. Mr. Hames also reads me a passage on, I want to just place this paragraph. It is not, which runs as follows. It is not the practice of the court to grant on an interlocutory application an injunction which will have this practical effect of granting the sole relief claimed. This does not deter the court from granting such interlocutory injunction as may be necessary to preserve properly, to preserve property or prevent irreparable change. Now, next paragraph is a part of the judgment of Justice McGarry, but then it's been shown as paragraph 58 because this is one of the most celebrated judgments. Woodford versus Smith. When I ventured to assert that this did not represent the law, Mr. Hames accepted that as being the case. I do not think that there's anything to prevent the law in a proper case from granting on motion substantially all the relief claimed in the action. It is true that in Dodd versus Amalgamated Marine Workers Union, it was said in the Court of Appeal that it was not the usual practice or the general rule of practice to grant on motion all the relief claimed in the action. But this language is general rather than absolute. The judgments are very brief, no reasons are given, and there have been later decisions. Thus, in Bailey versus Bailey, Lord Denning, Master of Rolls, flatly said that it seemed to him that there was no such rule. In this, he based himself on what Lord Justice Sargent had said in Attorney General versus Stockton on Tees, where there is what I may call a reasoned demolition of the supposed rule, the basis of which seems to have been an objection to trying the same point twice over. In Bailey versus Bailey, Justice Harmon referred to the supposed rule as a theory which had, in his view, long been exploded. See also Haywood versus so and so and so. I have briefly referred to these authorities, which were not discussed before me since there was no need, because it is time that the passage in the Supreme Court practice, which I have read, received the firm touch of a revising hand. Plainly, in the present case, the objection which Mr. Hames raised but did not press is no obstacle to granting the injunction sought. In my judgment, looking at the case as a whole, there are no grounds upon which the court should refuse to grant an injunction. It goes on and on. Then Indian paragraph 60 is Haywood versus BDC properties. Then 61 is Indian cables. That is just O'Neill Shen's division bench judgment, where mandatory injunction for restoring possession was given. Para 61, Indian cables. Then Hindustan Development Corporation versus Modi Loop, which is Ashok Ganguly's division bench judgment. Para 62. I will read out that quotation from Para 62. The other point on the basis of which the learned judge has dismissed the application is that the orders sought for was in the nature of main relief by way of an interlocutory application. It is well settled that in given circumstances, court can always pass interim relief in the nature of final relief, though such a power is required to be used sparingly and with utmost caution, but it cannot be contended that the court is precluded from passing an order in an interlocutory application which would result in granting a final relief. Now, and so on, so forth. It goes on from 63 onwards up to page 80, up to para 88, or should now paragraph 89. I will just come to the summary of the law as done by the learned, by Justice Banerjee. Numerous decisions have been cited before us as to whether or not an order in the nature of mandatory injunction can be passed by the court at an interlocutory stage, or an order can be passed at an interim stage which amounts to granting final relief in the suit to the plaintiff. We have noted all such decisions here and above. There does not seem to be any confusion in the legal position in this regard. There is no absolute proposition of law that a mandatory order cannot be passed at the interim stage. Normally, such an order is passed sparingly. However, if the facts of the case so warrant, the court will not hesitate to pass such an order, and will be well within its jurisdiction to do so. Similarly, if the facts of a case demand a drastic order at an interlocutory stage, which may amount to granting the final relief in the action to the plaintiff, the courts will not be reluctant to do so. There is no absolute bar in law in this regard. We feel the respondent number one had a just and legitimate grievance, and justice has been done by the Honorable First Court. This I must point out first thing now. This order was modified, not I would not say reversed, was modified by the Supreme Court. But on this issue, no. It's an unreported order, or she will find. The interpretation given was a bit different. Paragraph 5, there, because the RBI guideline was interpreted differently. And the order is set aside and the interim order is passed on a different line, but not on this issue. There is no discussion. There is no criticism or discussion. Now, actually, one thing Mr. Basu did not show on merits why this should be done is that I am saddled with the goods, because they have written to all the dealers and I have no right to use this product with this trademark. That I can't sell these products. So everybody has been stopped from buying from me also. So not only is this a contractual obligation, actually I want to show those letters which are which are which were written by the phone page, which were written by them to all the dealers. Yes, yes. As you will see from page 88 of the petition and a series of the letters to the Ministry of Defense.
Yes.
This is their right as to the Minister of Defense, who is our main buyer. Now, Lordship kindly comes to that they wanted to supply to the Ministry of Defense. Second paragraph, we would like to supply our power team hydraulic product to Indian Navy, and hereby request you to kindly register as one of the approved vendors. Kind turns the page. That they will supply to them. Lordship, yes, I'm sorry, Bala, this is 90. Yes, 97. 97. They have approached our customers, yes. Second paragraph. The Indian operations come under the Asia Pacific Operations umbrella, and I am in charge of the Indian sales operation. We don't have any entity by the name of Power Team India Limited, and we don't have any relationship with this entity. Hence, any letter that originates from Power Team India is not related to us or our brand. Nobody by the name of Mohanlal works for XPS. We do not authorize or change, authorize to change the until prior authorization. And then page 90. We do not have any entity by the name. 98, same effect. At the bottom, second last paragraph, Indian operations come under Asia Pacific and umbrella, and I am in charge of India. We do not have any entity by the name of Power Team India, and we don't have any relationship. These we could get lay our hands on, so we are stuck with the product. We can't even sell them as, short of selling them as scrap. So we are stuck with it. So that is the, now Lordship, the next, one more judgment I want to cite. Yes, and even though under the agreement, we have the right to use the trademark, page 36, clause 12. But that has been terminated, page 36, clause 12.
Yes, that has been.
That is. Now, Lordship, one more judgment I want to cite now. Judgment on next. Okay. Or to my approach, whatever, give me one. I will just. Lordship, one other, because what has not been Acro Automation's case, Lord Dennings, one page. At 1682, Lord Dennings' judgment, last paragraph, just below placetum H.
Yes.
Apply that principle to Rex Chain Belt and Rex International.
Page.
Page 1682.
Yes.
Just below placetum H. Apply that principle to Rex Chain Belt and Rex International. By refusing to supply chain to Acro, they interfere deliberately with this business of Acro. They make it impossible for Acro to manufacture or sell the low tow equipment. This interference with Acro's business is done by unlawful means, because it is done in obedience to an unlawful direction of SI. It seems to me that if a person complies with the direction by another, which he knows or has reasons to know is unlawful, then he's acting unlawful. He's aiding and abetting unlawful act. He participates in it. He cannot excuse himself by saying that he was under contract to obey the direction, because no person is bound to obey a direction which is wrongful. So here, Rex Chainbelt are acting unlawfully. They're refusing to supply Acro. It's a mandatory order to supply, and are doing so in obedience to unlawful orders given them by SI, and are guilty of contempt of court. They are thereby themselves using unlawful means to interfere with the business of Acro. It is an unlawful interference which can be restrained by the court. I think that the injunction should issue to restrain Rex Company from obeying the orders of SI, which purport to prohibit them from supplying chains. But I go further. In order to protect Rex Chainbelt and Rex International from being harassed, we should make a mandatory order against them. They are quite willing to supply these chain belts, which if they are free to do so. So we should make a positive order whereby they shall use all reasonable endeavors to supply the chains which are needed for the manufacture of the Lotto articles, the subject of the love license agreement. I know that this means that on this interlocutory application, we are virtually deciding the action, but that often happens. I would therefore allow the appeal and, subject to any consideration of details, make an order both in the negative and positive terms as asked in the notice of appeal. Well, I am agreeable to any equitable solution Lordship can make. Any equitable solution where admittedly this quantity of goods are lying with. I have bought them by paying them money. I can't sell those goods. I got them as their distributor. Well, I owed them money, of course, on the accounts, some money, but $4 million worth of goods, almost $4 million worth of goods I could pay. I can't be reduced to complete penury while this contractual obligation of theirs, which is supported by receiver's report, just deferred to a later stage, because then it will become Lordship. Lordship. Prayer C, Roman 1 has been granted, page 19.
So you are on D.
I am on D. Or if they don't repurchase, let the adjustment be given for the price. And it can be scrapped, they can do whatever they want. I'm only on D.
Yes.
So that is
Thank you. Today or some other tomorrow? Sunday. Come back. Counsel for the respective parties are present. Full stop. Counsel for the defendant / petitioner in GA number 2940 of 2018, within bracket review number 33 of 2018, has concluded his argument. Counsel for the respondent / plaintiff raised for time. In every submission made by the counsel for the plaintiff, is the matter 8 September.
Lordship. Read.
Fixed matter.
I am for the defendant.
Cross-examination.
Will kindly permit my junior to cross-examine. I've almost completed.
No. Mr. Dev, on the last occasion, in answer to question number 92,
এটা নিয়ে না আমাদের এটা নিয়ে
উনি তো আছে In answer to question number 92, you had deposed that you had entered the premises and seen the main areas of the premises. Areas of the building. Question 92.
Can you please share me? Please share me the.
Give the copy.
Did you find that the outside plaster was peeling off?
In answering question number 92, I said that I entered the premises through the main gate and going up to the staircases, but I have not up to the staircases, but I was not allowed to enter the tenant occupied area.
And did you find that there were cracks along the stair beam?
Actually, I was there to inspect the areas occupied by the tenants. In the common areas, while entering, I saw that the staircase is okay. Staircase and stairs were okay. I did not do any detailed inspection of the common areas.
I am suggesting to you that the walls of the rooms occupied by the tenants. I'm suggesting to you that the walls of the building and the common areas in particular are all damaged and in dire need of repairs.
I am not an expert to comment whether it requires whether the common areas require any repair immediately or not.
I am suggesting to you that the electrical wiring surface had not been maintained and is in need of repairs.
I am also not an expert to comment on your suggestion.
Did you notice that there was stagnation of water on the roof of the second and third floor?
Second floor roof was third floor and third floor roof was fourth floor. So there is no question of estimate. Second floor roof was the third floor and third floor roof was the fourth floor. There is no question of stagnation of any water in any side in any of those floor roof because that were all occupied by some bodies.
Did you find that the pipelines were leaking and there was water seepage?
I was not allowed to enter the tenant occupied portions. So there was no question of to enter the tenant occupied portion. Therefore, there was no question of any comment on pipe leakage in those areas.
Did you find that trees and scrubs have penetrated the outside walls of the building?
I was not allowed to enter into the tenant occupied area and I am confined to see the tenant occupied area. From outside, I have observed the building is not in a very good position.
that I was already mentioned in my report while doing the evaluation, while applying the evaluation grid technique. Evaluation grid technique, wherein I compared the comparable buildings, wherein I compared the comparable evidences position and the subject properties position.
Can I ask two more questions? Then I'll finish. Would you, as an expert, agree with me that it was necessary for you to examine both the inside and outside of the preferences in question for the purpose of coming to a proper valuation of the property?
As an expert, it is required to survey and inspect the property under question if it is a flat from inside, because the outside position of the flat does not make a large difference to the value, because it belongs to the entire building, not to the individual flat.
Would you also agree with me that the best possible evidence as to mean profits could be availed from the other occupants stroke tenants of the said building?
If those are available, the evidences, if available, reliable evidences, if available from the same building, definitely will be considered. But in no case it could be stated that these are the best evidences in comparison to the other evidences.
Now, you have in your report compared the said building with two buildings in the vicinity, that is Poddar Court and World Trade Center. Am I right?
You are right. World Trade Center.
Kindly take your report.
Give the report.
Yes, you are right.
And come to page 13 of 28 and 14 of 28. 13 of 28 and 14 of 28.
That report, yes, that is the report.
Do you find in paragraph 5.2.4, you have disclosed certain property snapshots?
Right.
Can you tell my lord as to who has taken these photographs?
Myself.
Have you deposited the negatives before this court?
These are digitally, these photographs are taken on digital camera, so therefore no question of any negative for submission. No question of submission of any negatives of these photographs.
I put it to you that no, I put it to you that the requirements of exhibiting digital photographs have not been complied with.
I do not agree.
is there any specific reason as to why your report does not contain pictures of the other two buildings with which you have compared the suit premises?
It is not essential to give photographs of the other two buildings. Therefore, I have not put the photographs of other two buildings in my report.
Okay. I suggest to you that for the purpose of comparing, it would be right and proper for an expert to disclose all evidence on the basis of which your report has been prepared, which has not been done in the instant case.
Yes, sir, you are right. That and I have submitted all the requirement of the evidences in my report.
That's
One. I suggest to you that the report which you have filed are incorrect. The contents of your report are incorrect. My junior has contents of the report are incorrect. Suggest to you.
I strongly disagree to your suggestion.
Strongly holo degree hobe na?
Strongly টা একটু জোরে হয়।
I further put it to you that your report cannot be accepted as evidence as you have not followed the principles of valuation of the suit property.
I do not agree.
I further put it to you that your report the report made by you has been prepared by the plaintiff only for the purpose of this litigation.
I do not agree.
This he didn't say strongly.
Sir, you have made an objection on strongly word.
That's a precise subject.
Thank you, sir.
আমি যাই না Millard, Millard, I think Millard, the plaintiff's witness
Close. No further evidence.
that
So you will
defendant would
adduce
have to-
evidence. How many witnesses you have?
Millard, as of now, I know two.
Two. Counsel for the respective parties are present. Full stop. This is a witness number?
This was PW two.
PW2 is present and this cross-examination is resumed and concluded. Also, counsel for the plaintiff submits that they will not adduce any further evidence. Accordingly, evidence on behalf of the plaintiff is closed. Also, counsel for the defendant prays for time to adduce evidence on behalf of the defendant. Also fix. Let the matter appear on 18th August.
No, Millard, give me some point.
Already it's evidence is going on from last at least 3 years. This evidence.
That's why I'm giving time. That's him. Let.
So 18th
18,
August.
no, 18th August other matter is there. That's why.
Millard, I really don't understand
Because
why do lawyers
they are
crib on this?
Yes.
They are acquiring 10,000 square feet, paying 30,000 rupees a month.
Okay.
Let's even see what the loss we are.
So why are you asking for mid profits?
Okay. When? Not before that. 22nd September
Yes.
at 12 noon.
Deeply.
For no, it is not possible.
It will take some time.
Of evidence, that's why. And if it is a small hearing, it can be
Yes.
adjusted. Now, even also the hearing is going in September and up
Deeply.
at 12 for witness action on behalf of the defendant.
If they file their affidavits to be served upon us.
No, they will adduce evidence.
No evidence is. Well,
Yes, it is
from
evidence.
the box.
Yes.
No affidavit. No.
Next.
Well, in this matter, I appear on behalf of the plaintiff by an order dated 11th of May 2024. Your Lordship speaks to direct the matter be converted from the regular division to the commercial division. And your Lordship had also further directed the formalities in pertaining to
Commercial.
Commercial Courts Act. My lord, while you were preparing statement of truth as well as the other other documents, we came to realize that the name of the company was changed from Jamshedpur Utilities and Services Company Limited to Tata Utilities and Infrastructure Services Company.
Take. Microphone.
We came back to your Lordship and Lordship had given an extension. Last extension was given on 27th of July. We had to completely format. There was an issue with the authority to be given by the managing director of Tata to the authorized signatory. That has been done, my lord. This matter was mentioned yesterday by because we had preferred. Our client has affirmed an application, and my junior had sought to take leave from your lordship for short service. We had in the meantime served the copy on the other side. The advanced copy has been served, my lord. And 9th in any event, the matter was.
What application you filed?
For name change. Unless the name change application.
Change of the name of the plaintiff.
Formal application, my lord. This may be taken up, the lordship had told my junior to come back tomorrow because in any case the matter was made returnable today. So this is the application. This can be taken up as on today's vote. This is a formal application. It obviously doesn't change the nature and character of the claim. It can be taken on board as on days today allowed. Once that is done, some amount of extension may be given, maybe 7 days, madam. The completion will be, the formalities will be completed, and then this can be placed for my lord, the case line.
Yes.
The application, madam?
Yes, I'm agree with.
No problem.
No problem.
I've already served them the advance copy. The affidavit is competency.
It's numbered, no numbered.
Your lordship wants to see this.
Not numbered. Not affirmed.
In the application,
Dismissed.
we had also sought for some.
Number is not been given.
Number could not be rate for short service. It's a formal application, it can be treated as a.
No, but unless and until number is not been given, how it can be taken as a. So, okay, I am giving the leave. Come tomorrow. Let the number be obtained.
Then kindly give me the leave.
Yes.
Can you be taken up day after that?
No problem. Counsel for the respective parties are present. Counsel for the plaintiff submit that initially the suit was filed before the original ordinary civil jurisdiction, and subsequently the suit was transferred before this court as the matter related to the commercial dispute. Counsel for the plaintiff submit that subsequent to the transfer of the suit, the plaintiff came to know the name of the plaintiff company is changed, and the plaintiff has filed an application for correction of the name of plaintiff has filed an application for correction of the name of the plaintiff company. Counsel for the plaintiff craves leave to file the said application and to issue a short notice of the said application to the defendant. In view of the submission made by the counsel for the plaintiff, leave is granted for short notice of the application and
this may be accepted.
the application filed by the plaintiff may be accepted and number may be provided. Please let the application along with the suit number 2 and the application may be placed along with CS number 203 of 2017 on today we are on 9 on 11th August 2020.
Great production.
Give the leave, huh? Manutosh.
I appear for the plaintiff. But we get filed evidence on affidavit. There were certain documents which we had enclosed, of which my learned friends had taken the point that my lord, these cannot be enclosed without the leave of the court. So my lordship had asked us to formally make an application. So, my lord, we made an application and a supplementary affidavit was also filed. We have served both on them, which is to be taken up today by my lord. Now, my lord, if your lordship kindly takes up their, my lord, objections. Lordship will find that, my lord, if lordship takes them, my lord, admission denial, affidavit of admission denial, which they have filed, although not in an affidavit form. My lord kindly takes that and kindly comes to my lord 21 onwards, to which they have objected, my lord.
Of their affidavit.
Yes.
Admission and
It should
denial.
have been an affidavit of admission denial, but it's an admission denial of documents, my lord, not an affidavit. Be that as it may, my lord, kindly comes to that document, page 4, item numbers 21 onwards, my lord. My lord, 21, lordship will find is a copies of invoices raised by the defendant, that is by them, upon the plaintiff between 2006 to 2014.
Yes.
Then, my lord, 22 copies of delivery notes against the delivery of purchase order of the defendants again them in between 2006 2014. Then, my lord, email dated such and such for opening of LC. This is also from them. Then there is an order of NCLT. It's a public document. Then there is a demand draft, which is the payment they have made in terms of the NCLT order. Then, my lord, there is a copy of a rent agreement. And then, my lord, a calculation sheet. Now, my lord, all of this has been, my lord, objected to them. Lordship will find at the right hand side column, my lord, under order 7, rule 14, subsection 3. Now, my lord, will kindly take, before I take my lord to the petition, this provision. My lord, order 7, rule 14, kindly will take, my lord. Order 6, order 7, rule 14. My lord.
Rule 14.
Yes, order 7, rule 14, subsection 3. No, now, lordship will see, lordship has got it, my lord. Documents relied on in the plaint. Production of document on which plaintiff sues or relies. My lord, kindly will see, this has been inserted in 1999 and has come into effect from 1st of July 2002. Where a plaintiff sues upon a document or relies upon document in his possession or power in support of his claim, he shall enter such documents in a list and shall produce it in court when the plaint is presented by him, and shall at the same time deliver the document and a copy thereof to be filed with the plaint. Now, what happens, my lord, if he misses out something? That's 2 and 3. Where any such document is not in possession or power of the plaintiff,
he shall, whenever possible, state in whose possession or power it is. And then 3, a document which ought to be produced in court by the plaintiff when the plaint is presented, or to be entered in the list to be added or annexed to the plaint, but is not produced or entered accordingly, shall not, without the leave of the court, be received in evidence on his behalf at the hearing of the suit. So therefore, my lord, it's a discretion. It's not that it's a complete bar.
Yes.
If I can satisfy the court that, my lord, this is required for the purpose of proper adjudication, then, my lord, and why I was not in possession of it, then, my lord, it lies with the court to pass an order, and then I can rely upon it, or leave may be granted to me. So, my lord, this is their objection, and, my lord, may I show why I was not able to, my lord, enclose these documents, and whether there are pleadings to that extent in my plaint. If this is a new document, my lord, which is not been pleaded, I would have understood. I could have got no leave from my lord. But whether, my lord, it is pleaded, and if pleaded, then whether I am entitled to the leave. Now, my lord, kindly takes the plaint. Paragraph. Now, kindly takes my plaint and kindly comes to, my lord, paragraph 3 of the plaint, my lord. Page 3, paragraph 3.
Yes.
And your lordship, if your lordship kindly side by side, my lord, keeps that chart, which, my lord, runs from, my lord, 21 of theirs, my lord, which they have objected. Now, the first, my lord, as I said, these are invoices and delivery notes given by them.
Yes.
Kindly takes page 3, paragraph 3 of my plaint. Between 2008 and 2014, the defendant placed several purchase orders on the plaintiff for an aggregate value in excess of rupees 3 crore. The terms and conditions for all the said purchase orders were identical, save and except the quantity, price, and technical specifications. All the said purchase orders stipulated a particular delivery period within which the goods were to be supplied by the plaintiff, and compensation for delay, liquidated damages if the same were not supplied within the time stipulated in the purchase order. It was always understood by and between the parties that time was not the essence of the contract, and the defendant accepted the goods supplied by the plaintiff beyond the delivery period stipulated in the said contract. A schedule containing particulars of the purchase orders placed by the defendant upon the plaintiff from 2008 to 2014 is annexed herewith and marked with the letter A. Number what has been stated and what is annexed is the same. These purchase orders, there was a schedule given. I have only, my lord, enclosed the invoices and the delivery notes which are of the respondent or the defendant itself to substantiate this pleading of mine. So it is not a new document that I am saying, or it is not that there is no pleading at all. It is in the evidence that I have pleaded for the first time.
You have placed in the plaint, that is the purchase
Yes,
order.
my lord, these are the invoices and the delivery notes related to that period.
Okay.
That is all. And these are defendant's document, not my documents that I have created. So the story is there, pleadings are there. Then, my lord, kindly comes to paragraph. Next paragraph.
21, page 2, 23.
Next.
Paragraph 30, page 30.
Kindly comes to page 38 of the plaint. My lord, this, my lord, email which they are objecting now is part of the plaint, page 38.
Yes.
Now, my lord, page 20, item number 24 is a order, my lord, which I have relied upon of the learned NCLT. Well, this is a public document. I leave it to my lord. And the next one is a demand draft, my lord, which they have paid to us, subject to, my lord, an order passed in my favor by the NCLT. This is also, my lord, a proceeding. In a proceeding, it has been filed in court. In terms of the court order, he has paid me. Then, my lord, is the rent agreement. Now, kindly comes to, my lord, paragraph 21 of the plaint, page 9. Well, at 5,000 numbers of BPL kits having an aggregate value of rupees 13,000. Page 9, paragraph 21.
Yes.
5,000 numbers of BPL kits having an aggregate value of rupees 13,50,000 having been manufactured by the plaintiff under and in terms of the said purchase order and in accordance with the specification and drawings stipulated in the said purchase order. This is the important part. The said BPL units are lying stored at a warehouse taken on rent by the plaintiff on a monthly rent of rupees 12,000 since 3rd December 2014. But all that I have done is enclose that rent agreement. So it's not that my pleadings are not there. I've even stated what is the rent to show that yes, I had hired a place on rent for the purpose of manufacturing.
Yes.
So this is nothing new, my lord, or no new pleadings that I'm putting in, just to substantiate it. Then, my lord, is a calculation of claim. But this is this, my lord, kindly comes to page 11 of the plaint. My lord, this particular, I have just put it in a chart. Even if my lord doesn't allow this one, my particulars in the plaint will suffice.
Page?
My lord, page 11, lordship comes. I have given a particulars of, my lord, claim. And this is for, kindly sees the amount 42,59,680. The same amount as that in item number 27. So I have just given a chart of that. But even if lordship doesn't allow 27, my lord, I have nothing to say because it's already there in the plaint. Particulars are there. So I am saying, my lord, there is nothing new that I have enclosed. All the pleadings are there. And moreover, my lord, he will cross-examine my witness. It is not an amendment that I am seeking. So he is not prejudiced at all. And my lord, kindly sees the provision, my lord. That, my lord, it is for my lord to look into the, my lord, application and the plaint as to, my lord, whether some new case is made out or whether, my lord, I am entitled to a leave because the pleadings are there. I only want to substantiate it by a, my lord, evidence. Now, my lord, kindly takes my supplementary affidavit once, my lord.
Supplementary affidavit?
Yes, my lord. I have filed, my lord. Can I take the period?
Yes.
My lord, prior to that, will your lordship, my lord, kindly take, my lord, my application, which is, my lord, I'm sorry, my lord, GA7, and kindly, my lord, paragraph 3 onwards, my lord, I have stated why I was unable to at that point of time. My application, which is GA7, to George ke deven to bar kore din bar na bar kore. It's a very, my lord, thin application only.
Yes.
My lord, kindly comes to page 3, paragraph 3, my lord. The petitioner plaintiff states that since all these work orders of dates long back, that it was taking some time for the plaintiff petitioner to arrange those work orders, and the plaintiff could not have waited for arranging all those work orders. since that would affected the limitation period for the filing of the aforesaid suit. Thus, the petitioner plaintiff had no other option to file the suit without annexing those work orders, but the pleadings of those work orders were duly taken in the plaint and detailed chart of the same was duly annexed in the plaint. But by the time the affidavit in chief was filed, all those previous work orders were duly arranged by the plaintiff petitioner and those were exhibited in the affidavit in chief. Then, my lord, paragraph 4 also, my lord, I have stated that, my lord, petitioner states that the plaintiff petitioner has pleaded that a go down and or a storage space was taken on rent by the plaintiff petitioner in the year 2004 for keeping the BPL kits manufactured and or fabricated by the plaintiff petitioner for supplying the same to the defendant. Since the rent agreement was of the year 2014 and the suit was filed hurriedly at the threshold of the limitation period, therefore the petitioner plaintiff could not annex the said rent agreement at the time of filing of the said suit, but by the time with the affidavit in evidence filed, the plaintiff petitioner has tendered the said rent agreement therein. Now, my lord, if your lordship kindly takes this, my lord, the supplementary affidavit, page 3, paragraph, my lord, 4.
Yes.
My lord, again, I have described all the documents. Then, my lord, kindly sees the petitioner plaintiff states that existence of all the aforesaid documents were known to the petitioner plaintiff, but were misplaced, and it was taking time to find some documents and gather and arrange them. Since the petitioner plaintiff could not have waited for arranging all the aforesaid documents because of the aforesaid suit was at the threshold of the limitation period for filing, and any further delay in the filing of the aforesaid suit would have barred the same on the ground of limitation. Thus, the plaintiff had no other option to file the suit hurriedly without annexing the aforesaid documents in the plaint, but the pleadings of those documents have duly been taken in the plaint. The plaintiff states that the aforesaid documents are vital documents for the proper adjudication of the said dispute and in between the plaintiff, and therefore for the sake of justice, plaintiff prays leave of this honorable court to tender the documents. So, my lord, all that I am saying is that, my lord, it is not that I have, my lord, annexed these documents without there being any pleadings whatsoever. And that is exactly what Order 7, Rule 14 says, my lord.
Yes.
That, my lord, if I can satisfy the court that there was a pleading, but I misplaced it, or, my lord, I did not have, my lord, the possession of it, or, my lord, there are other reasons, then it is for the court to, my lord, consider it, my lord, in view of the pleadings in the plaint.
Yes.
And that is, my lord, 14(2) and 3, my lord. So I was beseeching, my lord, since my learned friend can cross-examine the witness, my lord, this leave may be granted, my lord.
Okay.
Grateful, my lord. May I take my lord's leave, my lord?
Yes. May I be, my lord, I'll try to be brief, my lord. Lordship will see, even though in our statement of admission and denial, my lord, the objection has been articulated under Order 7, Rule 14. This will perhaps actually be governed by Order 11, my lord, because that is the amended provision of the Commercial Courts Act, which will govern. There's a Supreme Court decision to that effect also, my lord, that if an objection is taken under Order 7, Rule 14, that is to be treated
At 11.
under Order 11, Rule 1 to 5. That is what I will be relying on, my lord. If I may please place that provision.
Yes.
Hello, this is pertaining to disclosure, discovery, inspection of documents and suits before the commercial division of a high court or commercial court. Disclosure and discovery of documents. The plaintiff shall file a list of all documents and photocopies of all documents in its power, possession, control, or custody pertaining to the suit, and along with the plaint, including documents referred to and relied on by the plaintiff in the plaint, documents relating to the matter in question in the proceeding in the power, possession, control, custody of the plaintiff, as on the date of filing of the plaint, irrespective of whether the same is in support or adverse to the plaintiff's case. The C is, my lord, the exception that these documents can still be used to confront a witness in cross-examination, etc. If your lordship will kindly see. 2. The list of documents filed with the plaintiff shall specify whether the documents in the power, possession, control, or custody of the plaintiff are originals, office copies, photocopies. List shall also set out brief details of parties to each document, mode of execution, issuance or receipt, and line of custody, etc. And the plaintiff 3, my lord, the plaintiff shall contain a declaration on oath from the plaintiff that all documents in the power, possession, control, or custody of the plaintiff pertaining to the facts and circumstances of the proceedings initiated by him have been disclosed and copies thereof annexed with the plaint, and that the plaintiff does not have any other document in its power, possession, control, or custody. The explanation says, my lord, that the declaration on oath under the sub rule shall be contained in the statement of truth and set out in the appendix. Now, my lord, relevant to note that here, my lord, a defect was identified by the department. The statement of truth, my lord, was filed with your lordship. The copy has not been provided to us. Now, my lord, I expect that the plaintiff in the statement of truth may have made this declaration that in fact all documents in their power, possession, control, custody, etc. have been, my lord, disclosed along with the plaint itself. So, my lord, the application that is now sought to be filed is contrary to the statement of truth that the plaintiffs themselves have filed at the time of filing the plaint. Now, my lord, if your lordship will kindly take Order 11 as amended by the Commercial Court, 1 Subrule 4, after the explanation. In case of urgent filings, plaintiff may seek leave to rely on additional documents as part of the above declaration on oath, and subject to grant of such leave by the court, the plaintiff shall file such additional documents in court within 30 days of filing the suit, along with the declaration on oath that the plaintiff has produced all documents in its power, possession, control, or custody pertaining to the facts and circumstances of the proceedings initiated by the plaintiff, and the plaintiff does not have any other documents in its power, possession, control, or custody. So, my lord, this provides the mechanism of an urgent filing. Your lordship has seen, my lord, the relevant averment in the supplementary affidavit sought to be filed by the plaintiff, my lord, justifying the reason for not disclosing these documents along with the plaint, and my lord, belatedly seeking to introduce these by means of the affidavit in chief. My lord, the mechanism provided in the Commercial Courts Act itself is that in the event there is an urgent filing to be done, like my learned friends say, that my lord, limitation would elapse if they were to hunt for those documents and get their affairs in order, my lord. Then at the time of presentation, my lord, leave is to be obtained, and my lord, these documents are required to be filed within 30 days of filing of the plaint. My lord, the Supreme Court has time and again said, including in HON'BLE Sarabai, that the provisions of the Commercial Courts Act, my lord, are to be strictly construed. It is not a casual affair, my lord. Thereafter, my lord, if your lordship will kindly see subsection 5. This is the mechanism, my lord, if the procedure under 4 is not followed. If, my lord, it is not filed as an urgent suit, and, my lord, documents are sought to be introduced beyond the period of 30 days after filing the suit. The plaintiff shall not be allowed to rely on documents which were in the plaintiff's power, possession, control, or custody and not disclosed along with the plaint or with the extended period set out above, save and except by the leave of the court, and such leave shall be granted only upon the plaintiff establishing reasonable cause for not disclosing along with the plaint. Now, my lord, the reasonable cause and, my lord, the application, whether, my lord, subsection 4 or subsection 5 will apply, has been, my lord, interpreted by the Supreme Court in one decision, followed by the Delhi High Court single bench in one decision. I'm equipped with that. The principle is this, my lord. If the case is that, my lord, the documents were available with the plaintiff, it is not that the documents were in somebody else's control or custody. It is not that they were required to be subpoenaed by your lordship. If they were in the control and custody, it is only because of, my lord, urgency in filing that the plaintiff could not bring these on record along with the plaint, my lord. Then the mechanism is under Subrule 4. They ought to have obtained leave at that juncture itself, my lord, from your lordships, and file these documents within the period of 30 days. And, my lord, the Supreme Court has said, as followed by the Delhi High Court single bench decision, my lord, that if the plaint, is not filed as an urgent matter, if there is no urgent interlocutory relief made, my lord, there is no mechanism set out for separate urgent filing. But, my lord, that has to be demonstrated from the averments in the plaint itself, whether there is an interlocutory application filed and expeditiously moved simultaneously with the plaint, etc. In this case, my lord, that does not apply. This cannot be construed to be an urgent filing. In my respectful submission, leave has not been obtained. And, my lord, these documents are sought to be brought on record belatedly beyond the period of 30 days, even though they were in the possession, control, and custody of the plaintiff. So, my lord, they have slept over their rights under Subrule 4, which is the applicable provision, my lord. And in these circumstances, the Supreme Court, as followed by the Delhi High Court, my lord, when they have found that it is not an urgent filing, they ought to have obtained leave, my lord, at the time of filing of the plaint, and then disclose these documents within 30 days with an affidavit, my lord, on oath that there are no further documents in their power, possession, control, or custody relevant to the proceedings, that, my lord, they have slept over their rights, and this cannot be condoned. So, my lord, it is my respectful submission that when the law provides for a certain thing to be done in a certain manner, it can only be done in that manner and no other manner. My lord, the matter, what is the averment in the state, in the plaint, etc., is a supplementary fact. My lord, the essential requirement, my lord, strictly to be construed as provided in the Commercial Courts Act is under Order 11(1) Sub-Rule 4, which has not been complied with. May I just rely on one decision? Sir, if you want to. My lord, reported in 2022 SCC Online Delhi 3089. I'll just, my lord, indicate the facts. Here, my lord, commercial suit was instituted by the petitioner before the learned district judge, commercial court, against the respondent, my lord, for recovery of 66 lakhs along with interest as a commercial suit under the CPC as amended by the Commercial Courts Act, as required under Order 11 Rule 1 CPC as amended by the Commercial Courts Act, etc. Petitioner filed along with the plaint this application, my lord, under Order 11 Rule 1 Sub-Rule 1. And my lord, a list of documents on which the petitioner proposes to place reliance is thereafter filed. Kindly see paragraph 2, summons was issued and the petitioner seeks filed an application under Order 7 Rule 40 on such and such date, seeking to place on record certain additional documents which according to the application were necessary and essential part of the suit but could not be filed with the plaintiff due to negligence of part of the plaintiffs. The lordship skips 3 lines, my lord, the next sentence, as the suit was still at the stage of issuance of summons. That is relevant, my lord. Here, my lord, we have reached the stage of evidence. Thereafter, if your lordship will kindly take paragraph 6 of the judgment. This is the deliberation, my lord. In the order dated 8th April 2022, Learned Commercial Court ruled additionally that the documents that the petitioner sought to bring on record were not necessary for adjudication of the list. So, my lord, their application was rejected by the trial court. And, my lord, thereafter, paragraph 8 onwards, the law is discussed. Statutory scheme of Order 11, Rule 1, Sub-Rule 1, Sub-Rule 4, and Sub-Rule 5 of the CPC as amended by the Commercial Courts Act. So, my lord, here in this paragraph, they say that objection, even though taken under 714, my lord, of the CPC, is to be treated as an objection under 11 of the Commercial Courts Act. And paragraph 9, my lord, in case of urgent filing, Order 11 Rule 1(4) permits additional documents to be filed by the plaintiff within 30 days of filing of the suit, subject to grant of leave by the court. Documents which have not been brought on record either under Sub-Rule 1 or Sub-Rule 4 of Order 11 Rule 1, i.e. documents which have not been brought on record till expiry of 30 days from the filing of the suit, may be brought on record under Order 11 Rule 1 Sub-Rule 5, subject to leave of the court. Such leave, however, can be granted only on the plaintiff establishing reasonable cause for not disclosing non-disclosure of the documents along with the plaint. It may be noted that though Order 11 Rule 1(4) also envisages bringing on record of additional documents not filed along with the plaint within 30 days of filing of the plaint and requires leave of the court to be obtained in that regard, it does not specifically require the plaintiff seeking such leave to establish reasonable cause for non-disclosure of the documents with the plaint. That is a requirement restricted in case of the plaintiff to Order 11 Rule 1(5) in respect of documents which are sought to be brought on record beyond 30 days from the date of filing of the plaint. My lord, paragraph 12. So here, my lord, there was the issue of COVID limitation also which was pleaded. And if your lordship will kindly take paragraph 17. As already noted, Order 11 Rule 1(5) of the CPC requires the petitioners to adduce sufficient cause for failure to disclose the additional documents along with the plaint in order to be permitted to place the documents on record beyond a period of 30 days from date of filing of the plaint. The application filed by the petitioners in the present case does not contain any such disclosure as to why the 2 documents that the petitioner desires to bring on record were not filed with the plaint. It is admitted that the documents were in the possession, power, and custody of the petitioners even when the plaint was filed. All that is stated in the application is that the documents were not brought on record owing to negligence of the learned counsel who filed the plaint. Negligence of counsel, quite obviously, my lord, cannot be constitute reasonable cause, etc. It's not perhaps so relevant. And then, my lord, so, my lord, it cannot constitute reasonable cause within the meaning of Order 11 1(5), else the very requirement of adducing reasonable cause for failure to disclose documents with the plaint would be reduced to a formality. The learned commercial court is therefore perfectly justified in holding that no reasonable cause for failure to file two additional documents along with the plaint has been shown by the petitioners to exist. And my lord, this decision, I beg your pardon, my lord, paragraph 24 is also relevant, 25 onwards.
Yes.
Yes, if your lordship will kindly turn your lordship's attention to paragraph 25. It says, in the commercial suits, the time period and other formalities stipulated in the Commercial Courts Act are binding and are required to be strictly followed. This is apparent from the decision in Sudhir Kumar case on which Mr. Khurana places reliance. My lord, this is a decision of the Supreme Court. I will give your lordship the citation. The Supreme Court has strictly examined the issue of availability of the appellant in that case of the benefit under Order 11, Rule 1, Sub-Rule 4. On the basis of the facts before it, the Supreme Court has held that filing of the plaint by the appellant in that case could not be treated as an urgent filing, as would entitle the appellant to the benefit of Order 11, Rule 1, Sub-Rule 4. I place reliance on this paragraph, my lord. Paragraph 27. The situation in the present case is worse insofar as the applicability of Order 11, Rule 1.4 on facts is concerned. The suit filed by the petitioner was a simple money suit. No application for interlocutory relief was preferred therewith. The mere fact that the suit happened to have been filed by availing the benefit of extension of limitation as conferred by the orders of the Honorable Supreme Court in cognizance for extension of limitation. This pertains to the COVID limitation. Cannot by itself justify treating the filing of the suit as an urgent filing. No urgency of any sort is reflected in the pleadings in the suit, even if there is no prescribed format for urgent filing in the CPC or in the Commercial Courts Act. This is with regard to paragraph 36 of the Sudhir Kumar decision of the Supreme Court. It makes it clear that the facts of the case should disclose urgency in the filing of the suit in order for the benefit under Order 11, Rule 1.4 to be available. In the present case, the facts do not disclose any such urgency, as is correctly pointed out. That being so, applying Sudhir Kumar case to the present case, it cannot be said that CS such and such was instituted as an urgent filing by the petitioners. Per sequitur, Order 11, Rule 1.4 would not be available to the petitioner in the present case. Inexorable result is that the additional documents in the present case, having not been filed with the plaint as required by Order 11, Rule 1.4, the plaint not having been filed as an urgent filing as envisaged by Order 11, Rule 1.4, and no sufficient cause for not filing documents with the plaint within meaning of Order 11, Rule 1.5, having been adduced by the petitioner, no error whatsoever can be discerned in the impugned order of the learned commercial court, refusing to take the said documents on record. My lord, the Supreme Court decision that is relied, that is, your lordship will find in the footnote 4, Sudhir Kumar versus Vinay Kumar, 2021 SCC Online, Supreme Court 734. I'll just give your lordship the relevant paragraphs of that judgment as well and hand up a copy, my lord. Relevant paragraphs are 9.2 to 9.4 and 10.4. This also says, my lord, that to avail of the exception, my lord, under Order 11, Rule 1, Sub-Rule 4, which, my lord, requires that leave is to be obtained at the time of filing of the plaint and additional documents to be filed within 30 days thereafter, my lord. It has to be filed as an urgent.
That in terms of the
lordship. That portion of the Supreme Court judgment is quoted. That is not the case in the instant matter, my lord. So the mechanism provided in case of urgent filing, that is the case with which they make this application, my lord, that documents were available with them, but because of the urgency and, my lord, limitation elapsing, they could not bring it on record along with the plaint. Mechanism available was Order 11, Rule 4. They have not availed of that because this is not an urgent filing, my lord. And, my lord, today we are at the evidence stage. This is my respectful submission.
My lord, may I give a reply? My lord?
Yes.
My lord, the case is not under 11.4, but the case is under 11.5. Case, my lord, under 11.4 is that for an urgent filing. My lord, that mechanism, perhaps, my lord, the legislative intent is, my lord, something which has to be, my lord, filed with the leave of court, but usually that leave is, my lord, never opted for in any of the suits. Usually we've come with an interlocutory application, my lord, and do it. Because there are judgments to that effect of this court, my lord, that what would be, how do you show your urgency? So this is a case where, my lord, it falls under 11.5.
No, this is regard to the compliance of the provision of that
Yes.
12A. Correct.
12A, correct, my
12A.
lord.
That is 12A. No, with regard to 11.4, leave to file without the document you cannot file, leave to file this document subsequently.
Yes, but, my lord, there is a provision also which lordship has to see, which is, my lord's independent of 11.4, that is 11.5. Just like, my lord, Apropos, my lord, 7.3.
Yes.
My lord, kindly sees 5. The plaintiff shall not be allowed to rely on documents which were in the plaintiff's power, possession, control, or custody, and not disclosed along with the plaint, or within the extended period set out above, that is 11.4. Now, my lord, save and accept. So this discretion is still given to the court.
Correct.
Save and accept by leave of the court, and such leave can be granted only upon the plaintiff establishing reasonable cause for non-disclosing along with the plaintiff. So, my lord, 5 is an independent provision which a discretion on the court. My lord,
No, but the problem is here.
yes.
You have made out a case that you are having the document, but it is not.
Why I could
available,
not.
it was not
Why I
available.
could. Exactly. That's
So
exactly
if it
what is.
If you go by that, so first you could comply with the 11.4.
My lord, even if I do not comply with 11.4, my lord, kindly see 11.5, it is independent of 11.4, because kindly see the first line. It says plaintiff shall not be allowed to rely on documents which were in the plaintiff's power and possession. So I am in power and possession, control or custody,
Correct.
not disclosed along with the plaint, or within the extended time set out above, that is 11.4.
So you are not.
Covers.
Correct.
Now, my lord, save and accept. There is a comma. Save and accept by leave of court, and such leave shall be granted only upon the plaintiff establishing reasonable cause for non-disclosure. So if I am able to satisfy my lord that there is a pleading in the plaint, I was in possession, but I could not due to A, B, C, D reasons, my lord, which I read out from the paragraphs, which is not a new case that I have made out here.
Yes.
Now, my lord, then it is the discretion of the court. The court may exercise discretion, may not. So 5 is independent of 4.
Okay.
4, my lord, is for urgent filing. I have no doubt about it. But what happens, my lord, if, my lord, there is a case which is apart from 4?
Okay.
Then it comes under 5, and the lordship has got the discretion, my lord, to give the, my lord, right to the party to file it. If, my lord, it is for proper adjudication, and if it is pleaded, lordship has to see case wise. I'll distinguish this case. The lordship has to see case wise whether, my lord, I have pleaded or not. I have pleaded. It's not a doubt. There's no doubt that the plaint contains the facts. I have in fact given certain charts also. But I have only, my lord, at that point of time, my lord, I did not, my lord, have, my lord, all the, my lord, documents, my lord, in totality. So, my lord, I had to file it and wait now. But, my lord, that is the reason that lordship has to look into. That's the discretion with lordship has to allow, and whether this is going to prejudice the client. He's going to cross-examine my witness. It is only, my lord, my chief has still not happened. So, my lord, it is, my lord, in view of that pleading.
That's why the grounds which you have taken, you have a document, but you could not file at that point of time because it was not
For whatever reason, my lord, I'm not going in the reasons.
And admittedly, it is a commercial suit.
Yes.
It is a commercial suit.
Yes, I am only, that is why reading 11.5.
That's why you have not taken the recourse on, you have directly filed the commercial division. Now, once you have in your pleading in this application, you have stated that it was with you, but it was not available with you, and due to the limitation period, to avoid the limitation period, urgently you have filed without disclosing the document. Okay.
Without annexing those documents.
Annexing the document. If it is not annexing and you had the knowledge, that so why you have not complied with the 11.4 but taking the leave from the court?
Yes, because 11.4 I could not have, because, my lord, at that point of time I was not even aware whether, my lord, I will be able to get these documents or not. My pleadings were there. That is the, my lord, uncertainty. I can take a leave, my lord, of 11.4 when I am having it, but I am not able to enclose it due to certain reasons. But my pleadings are, my lord, different. My pleadings are that my pleadings are that this has happened.
Yes.
But, my lord, at that point of time, I did not have the entirety.
Yes.
So that is why I fall under 11.5. Okay. That is why I have to seek the leave.
Okay. With respect, my lord, that is perhaps
that
not
is
the
why,
case.
my
Made
lord,
out
I had to
affidavit.
seek
The
the leave.
affidavit stated that they had all the documents.
Yes, my lord, that is why I have to seek the leave. Otherwise, I did not require the leave. Now, my lord, kindly takes apropos this judgment. Lord, kindly sees, first of all, paragraph 2 of this judgment says, necessary, my lord, towards the middle, lordship will find, certain additional documents which according to the application were a necessary and essential part of the suit but could not be filed with the plaintiff. My lord, mark these words, due to negligence on the part of the plaintiff.
Where from you are reading?
My lord, paragraph 2 towards the middle, my lord. Kindly see. Summons, I am reading from the beginning, my lord. Summons were issued in CS number such and such. Petitioner has filed an application of Order 7 Rule 14 on such and such, seeking to place on record certain additional documents which according to the application, so applicant is only saying on oath, were necessary and essential part of the suit but could not be filed with the plaintiff due to negligence on the part of the plaintiff. That's not my pleading. Neither my learned friend is saying negligence on my part. So then, my lord, this is a case on a different footing altogether.
Okay.
His case is that due to negligence he could not file.
Correct.
Now, my lord, kindly takes paragraph paragraph 17 again, my lord. Paragraph 17. What is the case before the Delhi High Court?
Yes.
Towards the middle, my lord, paragraph 17, there is a sentence starting, all that is stated.
Yes.
Lordship has got. All that is stated in the application is that the documents were not brought on record owing to negligence of the learned counsel who filed the plaint. Negligence of counsel quite obviously cannot constitute reasonable cause. This is the reason for rejection.
Yes.
It will vary from case to case, my lord. Then, my lord, may I take, my lord? There's a Supreme Court judgment referred to in paragraph 22, my lord. Kindly comes. My lord, paragraph 36 of that Supreme Court judgment. Kindly sees, my lord, the conduct, my lord. May I read, my lord? Now, so far as the other documents ought to be relied on, produced as additional documents other than the invoices are concerned, the same stands on different footing. It is not disputed that in fact it was specifically admitted and so stated in the application that those additional documents other than the invoices were in their possession but not produced, being voluminous, and that the suit was filed urgently. However, it is to be noted that when the second suit was filed, it cannot be said to be an urgent filing of the suit for injunction, as the first suit was filed in the month of October 2018 and there was an ex parte ad interim injunction order passed, and thereafter the plaintiff withdrew the said first suit with liberty to file afresh as per the Commercial Courts Act. So therefore, my lord, this is an habitual person. He's been doing it. Now, my lord, kindly comes to my lord, kindly comes to the paragraph, which is, my lord, paragraph 26. Before I, my lord, take my lord to the last part. 26. The Supreme Court has strictly examined the issue of availability. So what lordship has to look into is the issue of availability. Now, my lord, kindly takes apropos this, the last paragraph, paragraph 29. The inexorable result is that the additional documents in the present case having not been filed with the plaintiff as required under Order 11 Rule 1, the plaintiff having not been filed as an urgent filing. No, now, my lord, this case is not a case apropos 11 Rule 5, Sub Rule 1, Sub Rule 5 of the, my lord, Code of Civil. This is a case of Rule 4. Kindly sees no sufficient cause for not filing the documents with the plaintiff within the meaning of Order 11 Rule 1.5 having been adduced by the petitioner. So this wasn't the application under 11 Rule 1.5. This was an application under more to be read under Order 11 Rule 1.4.
Yes.
No error whatsoever can be discerned in the impugned order. So, my lord, unless that application had got, my lord, the reasons to qualify it under Order 11 Rule 1.5, my lord, obviously the court has dismissed it. Mine is a case under Rule 5.
Okay.
Lordship will consider the discretion if Lordship feels so.
Okay,
And
thank you.
my submission is only that the case made out on affidavit
Rep-
is, my lord, for invocation of
reply-
rule 4 and not
reply-
5.
Reply to a reply. Anyway, I will never stop my learned friend.
That always
I'm
happens.
most
Yes. He my lord, I will never stop him.
Very grateful.
Grateful. my lord.
Counsel for the respective parties are present. Hearing in connection with GS 7 of 2023 is concluded. Fix for orders.
Grateful.
My lord, item 6, not
Lordship, I'm for the plaintiff in this matter.
Which
Lord-
one?
Item 6.
Next
OCDs.
item, Lord, this can be, Lord,
Lordship, the matter is incorrectly appearing today. If your Lordship takes up the order dated 31st of July, Lordship had made it returnable on the 16th of August. Lordship
Yes.
kindly fixes it on the date. We'll come back with our submissions.
Yes, but not, I have no problem with that. Not, I appear for the state note. We had we have served our written statement to my learned friend. This was not in fact affirmed in 2019, but due to not a communication gap, it was not filed. But I've spoken to my learned friend's advocate on record, but they have no objection to it being filed.
Lordship,
but
we
it
are
can.
opposing the filing of the written statement. This is a significant. That is
I
the
have-
instruction that I have received.
have a
Lordship kindly places it on the
I have a
16th.
communication on text saying that.
Lordship fixes it on the 16th.
Okay,
My
come-
learned
come
senior
on,
will
sit.
come and address your
Let
lord.
her senior.
But
Uh,
no, this was a regular suit,
Counsel for the respective parties are present and submitted. The matter is already is fixed on 16th August 2023 and they already fixed on 16th August. Accordingly, let the matter appear on 16th August 2023.
Grateful.
That's
Before my lord writing a short.
Yes.
My lord, the granted leave to file the written statement. My lord, they were supposed to file by Monday. My lord, duty invalid.
in that who will accept the written statement in that paper?
Because my lord, it is affirmed in 2019. My lord,
So
my lord granted a leave. My lord.
What? That's why there is a report in that. There is a report in your case. I have received some report from the department, so that cannot be. Let the when the matter is fixed.
On 11th, my lord.
11th, let it come on 11th.
My lord, may be permitted.
Yes.
Non-commercial matter was for number 2.
What do you want?
It was to be mentioned.
Fix for hearing.
Fix
Fix for witness action.
Other side has to be.
You are appearing for the plaintiff. Cross examination is going on.
No, nothing. Everything is complete. The other side has to fight.
They has to bring the witness, defendant, but nobody is here.
Notice was given. Telephone was made by myself personally and requested him.
Who is appearing for the other side?
Other side. I don't know who is appearing.
To whom you have issued the notice?
Yes, have come.
Your Lordship, I am for the defendants.
Yes, madam. You are dependent witness.
Yes, Your
Correct.
Lordship. Yes.
So I am fixing a date.
Yes, Your
On
Lordship.
that day, you bring your witness.
Your Lordship.
Counsel for the matter is listed as to be mentioned on the prayer made by the counsel for the plaintiff. When the matter is called, counsel for both the parties appeared. Full stop. Counsel for the plaintiff submit that the witness on the side of the plaintiff is closed and the defendant has to adduce their witness. Full stop. In view of the submission made by the counsel for the respective parties, let the matter appear on 21st September.
My lord, this matter is pending since April 10th. And it may kindly make 5th of September. If it kindly.
No, but as per your choice, the date cannot be. I have to give the date as per my diary. I will fix the date on 5th September. But there is no time to examine the witness because total diary is fixed.
Then as your lordship deemed fit.
When? 21st September at 3 p.m. for witness action on behalf of the defendant.
Okay.
Yes.
All these are on the point of appointment of a receiver in a partition suit, and some are specific to a running business. So I would be humbly beseeching that if your lordship kindly
Yes,
takes
yes.
it. Now, the first one, your lordship will see it's a judgment of a division bench of this court reported at 14 CWN 248. The first judgment.
Yes.
Here, may I place it? First paragraph. This is an appeal from an order of the district judge of Patna appointing receivers in a suit for partition and accounts. So here the district judge had already appointed a receiver and the appeal was assailing that order. Now, my lord, will kindly come to the fifth paragraph. It appears that Babu Rajaram had always managed the family properties, and it is alleged that since his death, such properties are in the hands of his son Ramji Ram. Various acts of neglect on his part are alleged, but the main ground of the application for appointment of a receiver in this case is the fact that Shaligram can get no funds from the estate either for the maintenance of his family or for settling the affairs of the estate, to one half of which the arbitrators have declared him entitled. It appears that with certain reservations as to the partnership business, which seems to be in abeyance owing to the unfortunate quarrel and other matters, the claim of Shaligram is admitted, but the attitude of Ramji Ram has clearly had the result of cutting off all supplies from Shaligram's branch of the family. Under these circumstances, the learned judge was of the opinion that this is eminently a proper case for the appointment of a receiver, but he appears to have based his decision on the recalcitrant attitude of the objector in not admitting the validity of the award, and this is one of the grounds of appellant's contention before us that a receiver should not be appointed. But we find that the real ground of the order is the fact that the appellant is keeping the plaintiff out of possession of property to which he is admittedly entitled, and this the judge finds is a sufficient ground for placing the property in the hands of receiver. The main contention of Mr. Such and Such is that it is not a sufficient ground, and he contends that the principles which have governed these cases for many years under the Code of Civil Procedure of 1882 must still continue, and that it would be extremely dangerous to alter the settled practice of the courts in Bengal by a too liberal interpretation of Rule 1 of Order 40 of the present code. Under the old law, it was laid down that in any case it must be shown that the property should be preserved from waste and alienation. And then may I skip a few lines, the next paragraph, paragraph 9. But the worst property, the subject of the suit, find no place in Order 40 Rule 1, and the only point we have really to consider upon this part of the case is whether there has been a substantial change of law so as to give the courts in India the same wide discretion as the courts of equity in England have since passing of the Judicature Act. But I'm not troubling your lordship with the discussions on that law. Thereafter, your lordship would kindly turn over to paragraph 13 on the next page. We can therefore have no doubt that on the merits of the case, this is, as the learned judge in the court below has held, eminently a proper case for appointment of a receiver. But there are certain subsidiary objections taken by the learned counsel for the appellants, which we must briefly deal. One of these is the appointment of two learned vakils of the court as receivers, where a large banking business has to be carried on, is not an arrangement that can be supported either on the grounds of justice or convenience. But we find from the record and pleadings of the parties that the business, even if it has been formally wound up, is in complete abeyance, and the receivers will have nothing to do with the management of it. Another and more substantial objection is the receiver have had their remuneration fixed at 10% of the account of the gross collections. This is an estate which is not wholly zamindari, in which the receivers are liable to have large sums, but I'm not on this. We'll kindly see the last paragraph, the appeals were dismissed. So, here the court has upheld the appointment of the receiver, which was by the court below, my lord, in a suit for partition and accounts. Then if my lord kindly turns over to the next page, or rather the page thereafter, it's a judgment, my lord, reported at All India Reporter 1938 Madras 730. It's similar, really a 2-paragraph judgment. Yeah, 38 Madras 730.
Yes.
This is an appeal against the order of District Judge of East Tanjore appointing a receiver. In general, a receiver will not be appointed merely because a member of the family files a suit for partition. But there are certain circumstances existing which justify the order passed by the lower court. The plaintiff is entitled to as much as half of the property, and the quarrels in the family and the conduct of the first defendant have made it impossible for him in the past, during the pendency of the suit, to get his fair share of the harvest. And it seems probable that in spite of any precautions taken by the court, the plaintiff will not be able to secure his fair share in the income from the property so long as it remained in the hands of the first defendant. The plaintiff is a minor who has to depend upon his mother's relatives for the safeguarding of his interests. The land are situated only 2 miles from such and such, and the receiver seems to have been appointed only to harvest the existing crops. A part of that duty has already performed. It is hoped that the suit will be disposed of with further trial court, and if not, the trial court will doubtless to take account of the situation from time to time in considering what course should be adopted in the future. So, my lord, here it's in respect of, my lord, a running, my lord, harvest, my lord, that was the business from which my lord, the receiver has been appointed. Then my lord will kindly turn over to the next page. This is a judgment reported at 18 CWN 533. Once again, a division bench judgment of this honorable court. May I place it, my lord, in the first paragraph? This is an appeal against an order by which the court below has rejected an application by the plaintiff in a partition suit for appointment of a receiver over the subject matter of litigation. The plaintiff and the defendant are brothers and are owners of joint properties of considerable value and extent. In 1992, after the death of the father, the respondent, the eldest son, took out letters of administration of the estate with a copy of the will annexed. He was at the same time appointed guardian of the estate of the person and property of his infant brother, the present plaintiff, who went to England in 1906 and came back 3 years later. On his return, he demanded partition of the family estate, but not refusal from his brother. But it should be met with refusal. Accordingly, the plaintiff sued the suit for partition in 1910. On 22nd February 1910, a consent decree was made in the suit under which the properties were to be divided and allotted to the 2 brothers. Arbitrators were appointed to make the division, but the partition was not carried out for reasons which need not be recited for our present purpose. On such and such, the plaintiff commenced his fresh action for partition either on the basis of the award of the arbitrators or irrespective of it. On 22nd November, he asked for appointment of a receiver pendent late. This application has been refused by the court below on 4 grounds, namely, first, that the plaintiff has from time to time received from his brother who is in possession of the estate various sums of money. It cannot be said that the plaintiff has been kept out of possession of the joint estate. Secondly, that under the circumstances of the case, the estate will be managed better by the defendant than by a stranger as receiver. Thirdly, that the appointment of a stranger receiver would mean imposition of heavy burden upon the estate, which is already encumbered to some extent. And fourthly, that the plaintiff is not satisfied with the amount he has received from his brother. His obvious remedy is to move district judge to make an order for increase of his allowance. In our opinion, these reasons do not justify a refusal of the application for appointment of a receiver. Upon the fact stated, it is plain that the title of the plaintiff to 1/2 share of the estate cannot be disputed. The plaintiff has a majority. The plaintiff has attained majority and is entitled to the enjoyment of his share. When the partition is effected, he will be entitled to his share severally. But so long as the partition is not effected, he is clearly entitled to receive approximately 1/2 share of the net income of the estate. This aspect of the matter which was not appreciated by the court below, and the subordinate judge has made an order which is manifestly erroneous. It is desirable to explain the principles applicable to a case of this description. At one time, it was held in England that as between legal co-owners of land, the Court of Chancery would not appoint a receiver unless by consent. Ramsden versus such and such, or unless the applicant was prevented from exercising his legal rights of entering into possession and sharing in the management. May I pause here for a moment? Ours is a classic case of both of this. On entering into the property, I've been deprived of that Jangalpur property and also from the management of the of the firm, where I've shown documents, several documents that I've been actively participating. In the same way as between equitable co-owners, exclusive occupation by one co-owner, in the sense that he refuses to pay his co-owners their proper share of the rents and profits, has always been deemed a good ground for appointment of a receiver. After the Judicature Act, however, it has been repeatedly held that the court has jurisdiction to appoint a receiver until the hearing of a partition action or until further order, even though there is no exclusive occupation by any party, and the court will not hesitate to do so whenever it is just and convenient. The case for appointment of receiver is much stronger if a party to the partition action is in sole occupation. In such a case, any other party may obtain a receiver either of his share of the rents and profits or of the whole estate. Then the next sentence. The court may also allow the party in exclusive occupation to elect to pay to the others an occupation rent, or the court may require security from the co-owners in exclusive occupation to account for their share of rents to other co-owners. Consequently, in cases of this description, there are four alternative courses open. 1, the court may require security from the person in sole occupation. 2, the court may require him to pay occupation rent. 3, the court may appoint a receiver of the share of the plaintiff. Or 4, the court may appoint a receiver over the entire estate. In the case before us, there is no room for controversy that a receiver should be appointed in respect of the whole estate. The plaintiff is, as already stated, the owner of 1/2 of the share of the estate. He has attained majority, is a married man, and has a family to support. He is further engaged in this litigation and has to bear heavy expenses. If the defendant is directed to furnish security, the order would be of no avail to the plaintiff and would not afford him immediate relief in the least degree. If the defendant is directed to pay occupation rent, the plaintiff would be entitled to claim 1/2 of the income of the estate. But it would be difficult, if not impracticable, to carry out the order because the parties are hopelessly at variance as to the amount of the annual income, which has been estimated at figures varying from such and such. If a receiver is appointed in respect of 1/2 of the share of the plaintiff, there will obviously be an immediate conflict between the receiver and the defendant, and the management of the estate will be completely paralyzed. Under these circumstances, the only feasible and practicable course which can be appointed without detriment to the parties is to appoint a receiver of the whole estate. The next question for consideration is who should be appointed receiver? But here, my lord, the court has deliberated on that issue, and my lord, thereafter, my lord, joint receivers were appointed. So, my lord, here your lordship would see that, my lord, even in respect of a partition suit, my lord, the court has given certain instances. Those are not exhaustive. Those are merely, my lord, inclusive, illustrative, and your lordship had seen, my lord, from the facts of our case, subject, of course, to hearing my learned friends, my lord, for the defendants, that, my lord, the plaintiffs have discharged their prima facie, my lord, burden of, my lord, showing defalcation of funds from the estate, and also, my lord, ouster of the plaintiff from joint family properties. But these, in my humble submission, of course, your lordship would test that, in my humble submission would be sufficient grounds for appointment of the receiver over the estate. Now, my lord will kindly turn over to the next judgment. This is the last which I shall be relying upon. This is a judgment reported at All India Reported 1982, Himachal Pradesh, 62. May I place the first paragraph? This revision petition, Sri such and such petition, has assailed the order of the learned district judge Mandi Kulu and Lahaul Spiti districts and Mandi, dated such and such, who upheld the order of the learned senior sub-judge Mandi, appointing such and such as receiver. So, both the courts below had appointed the receiver, and it was a revisional application challenging that. Now, we'll kindly turn over to the next page and see paragraph 4. The respondents filed a suit in the court of the senior sub-judge for the partition and rendition of accounts against the present petitioner and others. The present respondents also filed an application for appointment of a receiver. The learned sub-judge, be ordered such and such, allowed the application and appointed such and such municipal commissioner as a receiver to take possession of the documents and joint businesses of the parties and to realize the outstanding debts of the businesses, supervise the transactions in the course of completion, to discharge immediate liabilities of the asset out of the assets of the business, and to do such other acts and to execute such other deeds as may be necessary for the ultimate partition of the business between the parties. The receiver was to get the remuneration in the sum of rupees such and such days. So your lordship has seen that the order was not only a receiver in respect of the property, but also in respect of the business. Then paragraph 5. It is contended by Mr. Such and such, the learned counsel appearing for the petitioner, that admittedly the petitioner has been running the business in the shop and was in possession of the same. It is further contended that even if it is assumed that the petitioner is not the exclusive proprietor in the business, but had been running the business as a karta of the undivided Hindu family, he has every right to be appointed as a receiver and to run the business. It is vehemently contended that under the facts and circumstances of the case, it is in the interest of the members that he is continued to run the business, as appointment of a stranger as receiver was wholly unjustified. It is also contended that the petitioner should have been appointed as a receiver by imposing certain conditions so as to safeguard the interest of the respondents if they ultimately succeed in the suit. Then my lord will kindly see the unnumbered paragraph, beginning with in this case also. But it refers to a case of my lord AIR 1954 Punjab 122. In this case also, a suit for partition of joint Hindu property was filed and an application for appointment of receiver was filed. The learned judge, while dealing with this aspect of the matter, observed as under. The sole question which had to be determined by the learned judge was whether there was sufficient ground for appointment of a receiver. In Mullah Civil Procedure Code at page such and such, it is stated that the court will not as a general rule appoint a receiver in suits between members of a family, especially where the family property consists of immovable property. But a receiver may be appointed in a suit for partition where there is a prima facie case of misappropriation by the managers of the family. This is the rule which governs generally appointment of receivers in disputes between the members of joint Hindu families. The learned counsel has also referred to another decision in this is 1948 Patna. This is a decision of a division bench of Patna High Court. In this judgment, it has been observed that generally speaking, in a partition suit between the members of a joint family, the court will not appoint a receiver except by consent, and especially when the family property consists of land. In such a case, special circumstances have to be proved in order to obtain an order for appointment of a receiver. For example, where the court is satisfied that the property in possession of the opposite party was in danger of being vested. It is also observed that where one member who is in possession of the entire family property on his own behalf and on behalf of the other members in his capacity as managing member resists the effort of another member to take forcible possession of some of the property, his conduct does not amount to an ouster of another family member of the family and cannot be a ground for appointment of a receiver in a suit for partition instituted by the other members. On the basis of these above decisions, it is contended by the learned counsel that even if relations between the members of the joint Hindu family may not be cordial and strained, it cannot be a ground to appoint a stranger as a receiver. It is pointed out that the receiver appointed by the trial court is to get a remuneration or such and such. Then, my lord, the next sentence, the receivers to appoint, the last sentence of that page, page 64, there is a bifurcation, just above that. It is also pointed out that there is no evidence on record that the receiver so appointed has any experience of running such a business. The learned counsel has vehemently urged that the respondents are interested in delaying the matter as they are running their separate businesses on the projection of the shop in dispute. But thereafter, my lord, your lordship will kindly, my lord, turn over to the next page at paragraph 7. I have minutely considered the contentions of the learned counsel for the parties, and have heard them at length. It may be pointed out that keeping in view of the fact that the parties belong to the same family and were closely related to each other, the possibility of some sort of mutual settlement between them was probed. At the suggestion of the learned counsel for the parties were summoned in the court, such and such, personally present. They state that the petitioner is to be appointed as a receiver. The respondent also is allowed to propose the name of a co-receiver to work with him in running of the business. He proposed the name of such and such, a retired inspector of mines, to be appointed as a co-receiver with the petitioner. He, however, took the name. I am not on that minute. Then the next paragraph. Paragraph 8. I am of the view that as a general rule, it is desirable that in a suit for partition and rendition of accounts, a karta of a joint Hindu family be ordinarily allowed to run the affairs of a joint Hindu family property. However, if there are sufficient circumstances to show that he is likely to waste the joint property or has committed any act of misappropriation or any other act detrimental to the common interest of the members of the joint Hindu family, or is otherwise unfit to act as such, any other person otherwise fit may be allowed to run the affairs of the joint Hindu family business. It is, however, in exceptional cases that a stranger may be appointed as a receiver. The main grievance of the respondents for appointing the petitioner as a receiver is that the relations between the parties are highly strained, and under such strained relations, he may act in a manner that may cause loss or prejudicial to their interests. Under such situation, the interests of the members have also to be safeguarded. It may be pointed out that case of the petitioner is that he is the sole proprietor of the business and that the business is not joint with the respondents. He has also placed on record some documents which would show that he is entered as a sole tenant of the shop in which the business is being run. At any rate, I do not deem it proper at this stage to decide that aspect of the matter. However, even if the business is to be treated as a joint business of the parties, it is to be seen whether under admitted position of the respondents, it is proper and desirable to uphold the appointment of the stranger as receiver, or the petitioner who is admitted to be a karta of the joint in the family business be appointed as a receiver instead. Then, my lord, kindly comes to paragraph 9. The petitioner Tilak Raj is appointed as a receiver to run the business. So the petitioner who seeks for appointment of a receiver has been appointed as a receiver as a business to run the business in the shop in dispute. It is further ordered that under the supervision of the senior sub-judge Mandi or any other officer of the court appointed by him, and in presence of both the parties, detailed inventory of the stock in trade, the account books and other registers, as well as furniture and other articles belonging to the business shall be made, and day-to-day running of the business shall be entrusted to the aforesaid receiver. Sri such and such receiver shall keep a proper and accurate account of the business conducted by him and shall submit the details of that account every month to the senior sub-judge Mandi. The respondent shall be entitled to look into the details of the accounts thus submitted by Shri Tilak Raj receiver to the senior sub-judge. Both the parties shall also be entitled to approach the senior sub-judge to obtain other adjustments of the powers of the receiver. So, my lord, in all these cases, my lord, your lordship has seen, my lord, in a partition suit, my lord, where I am not for one saying that it should be a matter of course. Unlike, my lord, in a suit for, my lord, after dissolution of a partnership firm. But in a partition suit where the plaintiffs have, my lord, at the interlocutory stage, my lord, discharge their initial burden. But here possibly your lordship would, my lord, appoint the receiver and also, my lord, consider the other prayers.
Okay.
Those are my submissions.
Thank you.
Well, there was one supplementary affidavit which was filed. We had already served it upon them long back, but we forgot to file it. May I file this? This pertains to one property which we have come to learn that the defendants are dealing. It has already been served on them long back.
Have you the receipt?
2nd September 2022. There.
Yes.
And may I take your lordship's leave?
But maybe come back on some other day because it's Malad.
Tomorrow it is fixed, no?
Tomorrow, Malad, I
It is
think
the
it's
last
not
day.
fixed, Malad.
Tomorrow is
These
the-
back-to-back dates were, I think, fixed at.
Today is the last date. Huh?
Yes.
Counsel for the respective parties are present. Full stop. Counsel for the plaintiff has concluded his argument in connection with GA number 203 and GA number 12 of 2021. Full stop. Counsel for the defendants prays for time. Let the matter appear on 25 September 2023 at 12 noon. Yes.
3rd September.
Commercial or non-commercial? Commercial.
The matter was listed on 7th August 2023, but none appears on behalf of either of the parties. For either of the parties, for the interest of justice, the case was adjourned till today. In the order dated 7th August 2023, it was made clear that if none appears on behalf of the plaintiff on the next date fixed, appropriate order will be passed. Today again the matter was called. None appears on behalf of either of the parties. No accommodation is sought for. Accordingly, CS number 74 of 2020 is dismissed for default. Interim order, if any, stand vacated. Consequently, all the GA applications are also dismissed. Yes. Nobody's there. Not today. Not today. Next.
My lord, I'm for the mother of the deceased. My lord, the learned counsel is on legs. My lord, kindly gives a short passover.
Why to be mentioned? Give the brief.
My lord, kindly passes it over for a short while.
Let me see, madam, what is the stage?
Very good.
And this is that matter where your lordship will put both the contesting parties in the box, my lord, the mother-in-law and the daughter-in-law. And my lord,
So what is the stage of the suit now?
My lord, in the previous occasion, my lord had directed issuance of citation. We had accordingly taken appropriate steps. We wrote 2 letters to the department, in fact, for issuance of citation. However, there are some procedural impediments, it seems.
Yes, a report dated so has been used. Testament dated.
দেখো 23/6 ধরলে বলো অর্ডার দিচ্ছে বলো
Yeah, there is a caveat.
Yes, my lord. However, the respondent on the previous occasion had.
Sabri Sen has filed the caveat.
Yes, on the last occasion, your lordship, when the matter was taken up on 7th of July, there was a specific query by your lordship as to, is there at all a caveat? To that, a specific answer was given that there is no caveat.
No caveat.
But there is a caveat.
Correct.
And more importantly, the caveat was lodged post application. So clearly, the caveat had complete notice of the PLA. And in such an event, the provision that governs the proceeding in a testamentary proceeding, that is Rule 24 and Rule 25 of Chapter 35, Your Lordship. Your Lordship will kindly take up Rule 25.
No, that this caveat was lodged on 18 January.
Yes, and the
Application-
PLA was filed before 11 January. And GA 121 was filed on 11th of January, together with the PLA.
Caveat was filed 18 January.
Yes, subsequent to the PLA.
Yes, subsequent to the PLA.
Subsequent. So they clearly had notice. So the procedure that ought to have been followed was to file an affidavit in support of the caveat.
Who is appearing for the petitioner?
Right. For the petition.
I'm for the petitioner.
Then
they had to file an affidavit in support of the caveat. They have not done so.
But who is appearing for the subrogation? There is
Subrogation. My learned friend appears.
Subrogation has already filed the caveat.
But caveat can be before receiving or can be after
Whatever it
receiving.
may be.
But I have not been served with there's no summons or the citations have not been issued.
It's not required to be. Your Lordship will kindly see Rule 25.
Once the caveat has been issued,
It
caveat
needn't be.
has been lodged.
Completely misconceived submission. And upon non-filing of the affidavit in support, which is to be treated as a written statement, the caveat should be discharged and the PLA should proceed as non-contentious.
What is my learned friend submitting? It's a application without any will, non-contentious will nahi. Or our submission misconceived.
So caveat should be discharged.
Non-contentious for a letter of administration without a will, non-contentious.
He should have filed his written affidavit in support. For 4 years, he has not, and he has been taking this point that nothing has been served.
Once the caveat was filed.
Caveat was filed before the citation was issued. Once the GA was filed in connection with the PLA, that is when the GA was served and the petitioner filed.
When the GA was filed.
GA was filed on 11th of January.
11th of January.
And immediately
together with the PLA.
Immediately on receiving the GA, this caveat was filed.
No, caveat was filed on 18 January.
18 January.
Yes.
18
So that is after the GA.
Yes. That's why I'm asking when the GA was filed.
11th of January, together with the PLA.
Who has filed the GA?
The
Who has
petition.
filed the
We have filed the GA.
Petitioner has filed.
But you have not filed the affidavit in support of caveat.
No, because the citation has not been issued. There can be caveats in two situations. One is the citation after the citation. One is pre-citation. Filing of a caveat before the citation does not absolve of the liability of the propounder or the applicant for in respect of a letter of administration to not serve the citation.
Citation
has not been issued.
Citation has nothing to do with the factum of filing of affidavit in support of the caveat by the caveator. Your Lordship will kindly see Rule 25 and 26. May I read, Your Lordship?
And you also not pointed out since 2018 till today.
I had specifically sought that direction on the last occasion, Your Lordship.
You have sought for issuance of citation, but you have not pointed out with regard to the caveat filed by them.
It was actually
You are
at
the
that moment, at the relevant contemporaneous time, this was done by some other advocate on record who was representing the.
That is the problem. When the court started putting pressuring, then other advocate change brief, this and that. This court has passed an order for issuance of citation. When the report has come, then advocate is very simple. My lord, I was not there. This court is passing an order on
But your lordship,
believing the submission of the parties.
but my lord, the caveat was lodged by my learned friends.
But he is appearing, you had the knowledge. He has not filed the caveat. You could have been taken out the application, discharge of the caveat. You have not taken that.
I bow down.
Then
That is
and you-
a shortcoming.
instead of doing that, you have played on the last occasion, you have played for issuance of citation. When the citations order was passed, then all the things has come in picture.
I bow down. That is indeed the case. Your lordship will kindly take up Rule 25 once.
That's why I am going to that. Yes.
Any person intending to oppose the issuance of grant of probate or letters of administration must either personally or by his advocate acting on the original side file a caveat in the registry in form so and so. Notice of filing of the caveat shall be given by the registrar to the petitioner or his advocate acting on the original side.
Then
25 का ना उन्होंने half. Where is 25? 25. Where the caveat is entered after an application has been made for a grant of probate or letters of administration, which is the scenario in the present case.
Yes.
With or without the will annexed, the affidavit or affidavits in support shall be filed within 8 days of the caveat being lodged, notwithstanding the long vacation. Such affidavit shall state the right and interest of the caveator and the grounds of the objections to the application.
So first of all, yes, for the rule 25, if the caveat is lodged within the affidavit or caveat is to be filed within 8 days from that.
Affidavit in support and consequence thereof, notice
Notice
to
of
caveator or file to affidavit. This applies only when the caveat has been filed prior to institution of the PLA. Where an application for grant of probate or letters of administration with or without the will annexed is presented after a caveat has been filed. So in the scenario, the caveat is prior in point of time. In that event, the registrar shall forthwith issue notice to the caveator, calling upon him to file his affidavit. This scenario does not apply to the facts of the present case, because in the facts of the present case, the caveat had been lodged subsequent to filing of the application. Consequence of not filing, 27, where the caveator fails to file any affidavit in support of his support of his caveat in compliance with Rule 25 or in compliance with the notice issued under Rule 26, the caveat may be discharged by an order to be obtained by summons.
So you have not received the notice. Caveator, you have not received the notice.
No. 26 notice does not apply to the caveator because the caveat was lodged subsequent upon filing of the PLA.
Correct. So what can be done now?
The citations, Rule 9 mandates citations to be issued to the rightful parties. That has not been done. Once I got the GA in connection with the PLA, I file a caveat that without citing me, you should not go ahead.
Yes.
So citation has not been served. My filing of caveat is not consequent upon receiving the citation. There can be caveats filed otherwise also, which prevents proceeding with the matter without serving notice to me. Here, good, bad, indifferent, till date, no citations have been issued. It is a fact that I have lodged a caveat, but that caveat is not in pursuance of the citation on which my obligation to file an affidavit would arise.
Caveat can be before or can be after.
Can be after.
Correct.
Yes.
And there are two provisions.
Yes.
25, 26.
Yes.
26, what the 26 say, where a caveat has been entered after an application. After the application for grant of probate is filed. So, but in this case, when the caveat was filed?
After.
So 25.
Yes, but I was humbly trying to draw a distinction between the mere filing of an application and service and serving of citation.
First you come to the complete the 25 first.
Yes.
Where a caveat is entered after an application has been made for a grant of probate or letters of admission with or without will annexed, the affidavit or affidavit in support shall be filed within 8 days of the caveat being lodged. So what is the duty of the caveator?
To file an affidavit.
So then,
but for that the service of the PLA.
Where it is provided under Rule 25.
But if your lordship kindly sees the rules prior to that, where it mandates service of
Which rule you have
citations, kindly sees Rule 9.
Rule 9, yes. Yes. Citation.
Yes, citation.
On an application letter, unless an order for the
A citation shall be issued to all persons having a right to take the grant prior to or equal to that of the applicant, unless such persons have signified their consent to the application.
That is always.
So
But
citation,
where it is mentioned that the caveat is launched, again the notice is required to
that-
the citation is
no, no,
required.
this rule in my humble submission has to be read in context of the entire provisions of this chapter.
Sorry.
Where if I have received the citation, thereafter I have lodged the caveat
Once
there.
you had the knowledge that the application is filed.
But I had only the knowledge of the GA. The PLA was never served. In GA, I filed my affidavit in opposition.
GA contains the number 0.
No, GA had the PLA number, but
Then-
in GA, I had filed the affidavit in opposition.
So GA might have been filed. GA cannot be born without any original.
I bow down. But as your lordship has also seen, that my lord, in a suit, an application is taken out. But unless the summons are served,
Okay, I am discharging the caveat.
I'm deeply obliged.
Lord, kindly do not do so.
I'm
I am discharging the
deeply
caveat.
obliged.
You challenge and you set the right.
But kindly permits us to.
I am discharging it.
But there is no application to that effect.
No.
But kindly-
Court find that you are not complied with that.
But kindly permits me to come back and address you.
No, sorry.
But kindly permits me, because today it was appearing as
If
to be
you
mentioned.
wanted to mislead the court, you mislead that.
No, I am not saying.
Then the court is again and again telling with regard to that, you have not filed the caveat within 8 days. You are telling that the notice, the citation has not been served. Once you have lodged the caveat, you entered into the GA. GA contains the PLA number. Then you are not for the last 5 years. What the court shall do now?
But this still, it still is not a case that citation has ever been issued.
Whatever it may be, but
if the
you have lodged the
citation-
caveat. You are not the person who are waiting for the citation. You have already lodged the caveat. What is your duty within 8 days?
But my duty within 8 days is to file the affidavit in support of.
So you are not filed the
But to
caveat.
the PLA. I have never been served with the PLA. I only have the GA. That is the whole difficulty. I have not been served with the citation of the PLA. They had taken out an interlocutory application praying for certain interim reliefs, to which I filed my
So
affidavit in
the
opposition.
time will be extended again and again.
Unless the citation is issued.
Where it is, you show me the citation is required once the caveat is lodged.
This caveat.
You show me the law that once the caveat is lodged, the citation is required for filing the affidavit of caveat.
May I try and assist your lordship on this aspect? But I come in.
No, I am only you assist me, no problem. Whole day you assist me. I putting the question, you show me the law. Once the person has lodged the caveat, again the citation is required to be issued. You show me that.
I shall try.
Not try, show me that.
But I was not aware of
So
this.
you persons are misleading this court before passing an order again and again. On the last occasion, 1 hour has been taken. All the parties telling that the notice was not issued. When the citation order was passed, then it has come from the office.
And it is still a fact that citation has never been issued.
That's why.
Still a fact.
But
so there is no question of misleading the court.
So you have not stated that you have filed the caveat. The situation would have been different. Order would have been different. You have filed the caveat. You had the knowledge that the caveat, but you kept silent and taken the order for the issuance of the citation from this court. And when the office has noted that, then you are telling that the citation has not been issued.
But it is still a fact that citation has not been issued. The fact is
right.
Yes, the fact is that the caveat was lodged, but that is pursuant to receiving the GA. So in the GA, the pleadings were complete within the date specified. But that GA was taken out in respect
you
of
proceed with the GA, then I will pass an order, appropriate order in the PLA. Yes, what is the GA?
GA is not my application.
What is the GA?
My GA was initially filed for an order of injunction over the assets, but subsequently there were several orders that have been passed, Your Lordship. The first order that have been passed is 18th January 2018, whereupon a limited order of stay had been granted.
What GA number?
GA number 121 of 2018 was the first GA that was subsequently renumbered, Your Lordship. GA
Why it is to be mentioned? It is to be mentioned.
কপিটা সব অর্ডার গুলো আছে অ্যাপ্লিকেশন সব অর্ডার গুলো লাগিয়েছি
Plus appeared.
বলছো কিছুই বুঝতে পারছি না অর্ডার গুলো দাও ফাইল গুলো Okay, last supplementary that we had filed.
What is the last date of last order? What's
7th of July, Your Lordship. Order filed.
So what about the amount of bond? 10%?
Your Lordship, I have
Amount of the bond of 10% you're not deposited.
deposit of bond.
We had prayed for 5,000 as whatever will fall.
Amount of bond has to be executed.
We have
by-
paid for 5,000. Whatever falls from Your Lordship, we are ready to deposit that amount.
And you have gone through the report. Code department.
We haven't been served with the report, Your Lordship.
It cannot be.
We cannot.
Amount of the bond to be executed by the petitioner, which is normally being assessed at rupees 10% of the. What is the total value as you assessed?
Total value as per 17 crores is as per the affidavit of assets that has been annexed to GA 121, which is the affidavit of assets in the EPLA.
So 10% is to bond is to be executed, assessed at 10% of the total value. That is the report. You have taken the exemption.
You prayed for an exemption, though. That's why exemption in the application. EPLA.
Okay, whatever it may be, action, the matter is has to be mentioned today.
Yes.
I am fixing for orders.
Very well.
It cannot be taken up to the because
Very well.
only
Very
receipt of the report, it has been taken as a today. So I am fixing for hearing, you come ready with that. By an order dated 7 July 2023. This court has passed an order for issuance of special and general citation. After receipt of the report, after receipt of the order dated 7 July 2023, comma, the registrar insolvency has submitted the report, wherein it is mentioned that on 9 January 2018, when Sabari Sen, SHARBRI, Sabari Sen, has filed her caveat but has not filed the affidavit in support of her caveat. And as such, the department could not comply with the order dated 7 July 2023. After receipt of the report, the matter is fixed today as to be mentioned, as both the parties had appeared. Accordingly, let the matter appear on 17th August 2023 under the heading orders.
I'm deeply obliged.
Great.
Keen.
But could we have copies of the reports, my lord?
The parties are directed to inspect the record of the case, including the report of the registrar insolvency dated 1st August 2023.
Okay.
I'm deeply obliged.
But I appear for the plaintiff. I am opposing this application.
I'm waiting for the petition.
Yes. Ready?
Lordship will recollect, my lord. This is that matter, my lord, concerning that movie, Bengali feature film titled Blackmail, my lord, where, my lord, I was the financier, I am the plaintiff. Lordship will recollect, my lord, this is an application filed by my learned friend, my lord, in the nature of an Order 1 Rule 10 application, seeking expunging of his name. Lordship, on last occasion, my lord, I had tried to rely on order pass. Lordship will recollect. My lord, may I just hand over a copy of that order? But there is an order of injunction operating against all the defendants, my lord, including my learned friend's client, my lord. In that view of the matter, my lord. In fact, my lord, there was an earlier order passed by my lord, Justice Pathiria. Lordship will see this.
So you are for the defendant number?
Defendant number 5 and 6. Hello, defendant number 6.
Have you gone through the order? Last
My lord,
case?
have gone through the order, my lord.
Then after that also you continue with that.
My lord, no order has been passed taken defendant number 5 and 6.
No order. Kindly come to the last paragraph. You give the undertaking or you deposit the amount of rupees 5 crore, then I will release you.
My
24.
lord, paragraph number 24.
Yes.
My lord, my lord, if I may read out, my lord. My lord, as regards the D5 cassettes for UFO and digital and beta cassettes for satellite and beta cassette for local channel of the film Blackmail, the same were to be handed over to the plaintiffs in terms of the memorandum of agreement in terms of the clause 13 of the memorandum dated 2013. Accordingly, the respondent number 1, 2, and 3 are directed to hand over the aforesaid cassettes to the advocates on record of the petitioner. And the respondent number 1, 2, and 3 will also hold such cassettes as joint receivers without remuneration till disposal of the suit. The order of injunction passed above will also continue till disposal of the suit.
And my lord, para 23. Lordship, para 23 is where he's been restrained.
Yes, yes.
Paragraph 23, my lord.
Paragraph 23.
In view of the aforesaid, there will be an order of injunction restraining respondent numbers 1, 2, and 3 from realizing money on account of film so and so from any other respondents, including my learned friend.
My lord, I am a mere hall booking agent. My lord, I am not supposed to pay him money, neither I am supposed to pay the plaintiff's money, neither I am supposed to, nor I am supposed to pay the respondent's money. My lord, I am mere commissioning agent. My lord.
Then come to the order dated 18 September.
My lord, this order has been passed in my absence, my lord.
You're not challenging this order, and on the basis of this order, the order dated for 24 December 2014 was passed. Here you are also the party. Kindly see, he has now come to know that the box office collection and from the respondent number 4 to 11, who are distributors and exhibitors of the said film, payment is to be received.
My lord, let them show one scrap of paper to.
I am not telling let he show. I am not telling on that. Get it clarified this order from appellate authority or get it reviewed this order.
then your application will be taken up. Once the court has passed this order, the coordinate bench has passed this order in the same case, how you can be, if you have been released, then this order will be frustrated. Please consider that paragraph 2 of the order dated 18 September. Hello. Read again, read.
And the case of the petitioner is that it had lent an advance monies for making of the feature film, and in view thereof was entitled to repayment of sums to release of the film.
Correct.
He has now come to know that from the box office collection and from the respondent number 4 to 11, who are distributor and exhibitors of the said film, payment is to be received by the respondent number 1 to 3. No payment has been made to the petitioner. Hence, this application has been filed and orders sought.
Then come to the paragraph 13, paragraph 23 of the order dated 24 December.
My lord,
So respondent number 1, 2, and 3 has been restrained not to release the amount, and you are entitled to receive the amount, distributor.
My lord.
Correct. And here is the restraint order.
My lord, my only bone of contention is neither I am the distributor nor exhibitor. I am being falsely implicated as a party.
So order
But unnecessarily, I am dragged in between the proceeding between the financier and the producer.
What can be done? Court's hands are tied with regard to these two orders. Either you clarify, get it clarification from the honorable judge, or whatever it is.
My lord, in that event, my lord,
In the same jurisdiction, I cannot pass any order, coordinate bench. I
I'm seeing-
cannot release you.
my lord, in that event, I need to take instruction regarding filing of a separate application, my lord. Let this
It is
application.
binding to you, to this court also.
My lord, in that event, let this application go out of the list with liberty to mention it.
Counsel for the respective parties are present. List of counsel for the defendant number 4.
5 and 6.
That's one. Defendant number 5 and 6, who have filed an application being GA 9 of 2023 for deletion of their name from the cost title. After going through the order passed by this court dated 24th December 2014 and 18 September 2013. 2 days for time for taking appropriate instruction. We have the submission made by the counsel for the defendant number 5. Even 6, it will clear. Let the matter appear after 4 weeks. Is the matter on 12th September. Come on, 12th September.
Much obliged.
Lordship is fixing it on
12th September.
Grateful, man.
Yes, next.
Non-commercial, we mentioned file number 4.
Your Lordship, I am appearing for the defendants. This is that
Yes.
suit, my lord, where your
What is that
Lordship.
instruction?
Yes, my lord, I have taken instructions with regards to the amount, my lord, that the interveners are ready and willing to give. We are unable to go higher than that, your Lordship. Now, with respect to their prayers in the intervening application, they want to run the boarding business from the 3rd floor, which is lying empty, half portion of the 1st floor, and ground floor, which is not specified. They've just said ground floor. The only request that is made by my client is, instead of ground floor, the entire 1st floor and 3rd floor, if they're willing to run the boarding business, will not intervene. Ground floor, certain portion is taken up by the tenants, your Lordship, as had been indicated. And certain portion, 2-3 rooms have been taken for the storage of certain materials for running our business, which is our bread and butter, which is why it is difficult to find any alternate accommodation to do that. These are my submissions with regards to
So
the.
you want that The ground floor, whatever the tenants are there, tenants are there.
Tenants are there.
So that-
Certain
that will
portion
be
is,
rented
certain
with-
portion is
some
there.
person is with you.
Yes.
You will
So the
continue with
first
that
floor,
possession.
half portion that is with me, the first floor entirely and the third floor that is lying vacant. So the first and third floor.
But yes,
That is our proposal, Your Lordship. Half of the first floor entirely, third floor entirely, and for services places only. This is by our expectation.
no. He's telling that so, but half portion is in their possession.
Half portion is the position of the defendant. Sorry, plaintiff.
Your Lordship, as I think already was stated by the learned administrator and as I've been instructed also, half portion is with the interveners and half portion is with the
So you want the-
defendants, Your Lordship. So I am willing to give up my half portion. I am willing to give up my half portion, Your Lordship, and the entire third floor. The only thing that I'm objecting to Your Lordship is with regards to the certain portion of ground floor that I'm occupying for storage, my Lord.
So you are leaving, you will not pay the amount. You will. leave-
I am unable to, Your Lordship. Financially, they are unable to do that.
Only
That is why.
your ground floor possession should not be disturbed. That is
Yes,
your,
Your Lordship.
that is your answer.
Yes, Your Lordship.
That is enough.
Ground floor possession and the others are residential as had been indicated, my Lord. Yes, yes.
That's
That
the
is all.
fourth floor.
There is no dispute with regards.
That is the fourth floor.
Only humble submission if our consent may not be recorded. It as a consent, Your Lordship. Just a submission on instructions, my Lord, I'm saying if that could be.
Instruction I will record.
My Lord.
Yes. What is your submission?
That was our prayer, Your Lordship. I'm reading my prayer only. An order be passed permitting the applicants here to manage and operate paying guest boarding house business from entire third floor, half portion of the first floor, and ground floor wherever services are situated.
Entire third floor, half portion of the first floor.
And ground floor wherever services are applicable. Suppose water pumps are there. These all things are there for
So
service
that
purpose.
is common area, Your Lordship. Perhaps what is being indicated.
Against payment over 55,000 per month.
55,000 per month. And with regard to the taxes.
Taxes, I have also indicated, Your Lordship, in conveyance to the applicants also. No
My
operation
Lord-
of paying.
My Lord, if the maintenance and the taxes part be clarified in this order itself, Your Lordship.
Proportionate to the extent of my position and running of the boarding house, municipal taxes, electricity, my lord, and this cleaning and these all the things are concerned. We'll have to.
My Lord, in these circumstances, Your Lordship, we are also ready and willing to maintain and pay the proportionate taxes of the portion that.
Which you are in
Yes.
occupation. of.
Yes, yes. Only that.
And maintain, you can pay the electric and you can pay the
To
municipal
our
tax.
portion, whatever we are occupying.
Maintenance.
Yes.
And with
to
regard
that
to that, and what about the common water, what are there? Water pump.
Water pumps
Water
are
pump is-
there, underground water reservoirs are there, and overhead water reservoirs is there.
Hmm.
They should be used for the purpose of boarding and the paying as it was used earlier also.
My Lord, with regards to, I think there should be a share because it's a common. If we are also using it for our purpose, but they'll also be using a substantial portion for the boarding business, my Lord. There should be a share of the expenses. We
Share
cannot
of the
take it
expenses
completely
means water tax.
to water related, the maintenance, water tax, and that is the common maintenance area of the maintenance of the common area also, Your Lordship. Staircase and
That we
other
have said,
areas.
proportionately, this maintenance cost, this electricity, this all whatsoever.
Yes, special officer, what is your submission?
Lord, I really have nothing to say. I have submitted my reports.
Now with regard to, now again, if it is come now, the total responsibility of yours only.
So, very good.
Addition of party.
Total responsibility of yours only. Now the question is, the first floor, what the tenants you will collect the rent.
So no, my lord, the tenants on the ground floor.
But ground
So-
floor, what are
so
the tenants? you
Ground
will
floor,
collect the
I'll
rent?
collect the rent, my lord. Your lordship would kindly provide, my lord, for a bank account to be opened
Let
in the name of the
I will
estate.
come to that.
Yes.
With
So
regard
I
to-
will, so my lord, I will collect, my lord, the rent from the tenants on the ground floor. I will, my lord, keep a vigil that the activities that are being run.
Ground floor, tenants. How many tenants are there?
2 tenants, my lord.
So rent will be collected by you, huh?
Yes. And deposited, my lord, in the account of the estate, in the name of the estate.
So that is the tenant portion. Whatever you are having some portion, that the defendant number?
Yes.
Defendant, they are in
No,
occupation
I'll
of-
tell you, lordship, I'll just clarify, my lord. The defendants, my lord, there are 2 defendants. One defendant lives on the 2nd floor, one defendant lives on the 4th floor, and the terrace is also, my lord, in possession of the defendant on the 4th floor. They are both cordial brothers, and 2nd floor, 4th floor, and the terrace is with them. It's their residence. My lord, there, honestly, my lord, my interference is, my lord, not warranted. It's a family living there. And in so far, yes, and in so far as, my lord, the 1st floor and the 3rd floor is concerned, these entire 2 floors, my lord, will be the lodging facilities, which will be run by the intervener, who will deposit money. So, my lord, he'll also deposit money in the same account, I believe, where the tenants would deposit money, which account your lordship would provide
They
for
will
creating.
pay the amount to you.
Yes, but, my lord, in the same account,
Then
because
have to
estate,
you have to
they'll pay
deposit.
the estate, my lord. So the bank account, my lord, will essentially be for collecting, my lord, money from the intervener, who's one of the heirs who will be running the facilities, and the 2 tenants on the ground floor. And apart from that, my lord, whatever maintenance charges are there, whatever taxes are there, they will, my lord, be paying their respective proportionate shares. And, my lord, I'll ensure that the building is, my lord, clean, well maintained, and keep a vigil that no illegitimate illegal activities are being run, and that everyone is peaceful. And if there is any grievance, your lordship, my lord, will decide that if someone files an
But
application.
the problem is that intervener's application has been allowed.
Not yet, my lord.
Their
But
application is pending.
I believe, my lord, whatever your lordship decides, my lord, will dispose of that application. That's my understanding.
That is to
My prayer C be allowed also, my lord. Prayer C, that permitting the applicants be added as party. So that
Your lordship, with
Prayer
regards
C,
to
allowed.
that, if your lordship kindly remembers, I had raised that point where earlier your lordship, their ancestors had separated from this joint family, and there was a permission that was granted to the interveners to stay in that portion as a tenant.
So now the question is that unless and until they will not intervene, how the court will permit?
My lord, I mean, not that I'm required to say much in this, but your lordship will just consider whether they have a cavetable interest. The law, my lord, is well
That
settled.
is the problem.
So-
That is the problem.
If they have a cavetable interest, they'll be allowed to, my lord, come in as.
She is denying for that.
Your lordship,
disputing that.
your lordship may then, my lord, examine. Your lordship may pass an interim order.
That prayer, your lordship, because I had taken that stand in my opposition.
No. With regard to you have taken the stand. So unless and until they will not be implemented in this part, in this case, how the order can be passed on that
Your
scope?
lordship, the matter was heard at length on the last occasion, if your lordship remembers. Pursuant to hearing, your lordship had given this suggestion that if the interveners are proposing to do something that will giving a proposal to run a business which will be beneficial for the estate, so then your lordship was inclined to allow that prayer.
No, we did not agree.
So how they can be binding if they are not the party to the proceeding?
Are you disputing that they are the grandchildren of the deceased?
He is a tenant.
And we have the caveatable interest over the
No,
property.
that's fine. You may be a tenant or whatever.
Your lordship,
You are receiver, sir. Keep your limits.
alternatively, what I am being told, that alternatively, what we could do is that the portions that are in our occupation, we maintain, as I had stated earlier, the boarding business, and along with that, your lordship, the boarding business will carry on and pay the remuneration of the administrator.
That is
But the only difficulty is financially, we are not being able to go higher than 55. That is the difficulty.
My lord, there will have any difficulty in allowing added as a added party.
So she is disputing with regard now how to dispute. No. Again, I have to decide whether you have a cavetable interest or not. Then only it can be. Unless and until you will not you will not prove that you have a cavetable interest.
And I'm the grandson, granddaughter, grandchildren, my lord. Grandchildren, my lord. So I must have the cavetable interest, my lord. That is also pleaded in my application, my lord.
So you are also granted, taken leave from the filing written. Once it has been allowed, then it will come as a total suit. What is your submission with regard to adding the party?
Your lordship, as I had stated earlier, my lord, that with in a
What is your objection? Why you are telling that they are not a cavetable interest in the matter?
Your lordship, my only submission with regards to that is that earlier, your lordship, there was an understanding between the family members, wherein a settlement, wherein my lord, they had separated from this family, from this joint family, your lordship. And they had also taken a separate accommodation.
Yes, yeah.
That does not mean I will.
Separate accommodation, your lordship. And after that, these parties who are occupying that portion, they were only permitted, their ancestor was only permitted to occupy that as a tenant. This is my main objection, your lordship. So what I'm saying is, since they had walked out from the joint family, today, after it has been already converted to testamentary suit, the suit has also proceeded with your lordship. At this stage, they are coming in only when they have seen a slightest hope, my lord, that they can possibly get into they can extend their possession, because your lordship understands that I am not financially that capable right now to propose a certain amount that is higher than 55 to keep my possession of a certain portion, your lordship. This is the subject matter. So therefore, my lord, in that event, what I'm submitting is, once they found an opportunity that at this stage that we are not being able to run the boarding business, they have jumped in that opportunity, and now they are saying they have caveatable interest and they want to get intervened in the matter.
The statements made are not never admitted before the court or elsewhere, my lord. Given the documents has been produced before your lordship, what documents, under what documents?
But the 2018 PLA, you are slept to on the matter. Only after receipt of the report, you file this application.
Absolutely, your lordship. That is
you are not come forward.
And they were
Neither
aware.
You file the caveat, not the consent, nothing
Your
else.
lordship, there is a pleading. I'll show, my lord. I had shown on the last occasion also, they were aware of the proceedings.
Correct.
Not that they were not aware of the proceedings.
2018,
No
this PLA
sufficient
was
cause.
filed, notice was issued, other parties appeared, you are not appeared. So at this stage, what can be done?
My lord, we have not come across the notices served upon them because I do not know, your lordship. Had they come to know about the notices, they certainly would have come before your lordship, because they have the caveatal interest. They are very much interested in the property, your lordship.
The beneficiary also.
I'm the beneficiary in the administration also.
My lord, I appear for the plaintiff in this matter, my lord. My lord, what my lord today transpire, my lord, is a different stand taken by the different defendant from the earlier occasion, my lord. If your lordship sees, my lord, the reports, my lord.
Now she didn't want to continue with the business.
Yes.
She want to continue the business, but she is not able to pay the amount. Only she will pay the whatever the taxes and the remuneration.
Yes.
But now the court is getting best offer or whatever it may from the intervener.
Yes.
Now the question is that, and she is also ready for leaving the first floor, second floor and third floor, whatever it may be, and they may run the business of the boarding or whatever it is. Now the question is that they are not the party to the suit.
No, my lord, they are not, my lord. It was, my lord, this point was taken at the very first day, my lord.
Correct.
Now, my lord, what my landed friend will do, they will, my lord, continue with, my lord, the business. Now, my lord, that will not give them a right on the property, my lord.
Correct.
It was, my lord, on the first day, your lordship, my lord, clarified that it was, my lord, the special officer who is going to oversee this. Being an advocate, my lord, it is difficult for the special officer, my lord, to induct a tenant and then, my lord, regulate. So, my lord, what my landed friend is today trying to do is, my lord, the estate has to earn something, my lord. My learned friends, defendants are not in a position to run, my lord. My lord, they are
saying I'm not in a position to run. I may not be able to.
In a position to run, my lord, he is not going to be a shell out. My lord, the remuneration of the special officer is pending.
Not run. She wanted to run, but she is not able to pay the amount which they have
Exactly,
offered.
your lord.
Yes, my lord. The difficulty, my lord, that is, my lord, at stand, my lord, which is not from the record. My lord, initially, what they took the stand, there was a, my lord, business running. Special officer appointed, my lord. They come up with a leave and license agreement saying that I have given it to a third party. He is running the leave and license. Your lordship says, my lord, after the order of special officer, they could not have done it. Now they are taking the plea, my lord, we are not running it. Then these applications comes in, my lord. They again say, my lord, we are ready and willing to run it. My lord, today, my lord, our submission is that we are an interested party. My learned friend is also, my lord, a legal heir, my lord. The property has to be maintained, my lord. There has to be some fund, my lord. If he is willing to pay off, my lord will clarify that it will not create any right.
But can you see the prayer in the application? They let the note press. Can you see the prayer? They wanted to intervene. They wanted to be filed written statement. Then they wanted to run the business.
Run the business in exclusion of all the heirs.
So that if it's so, then this application will be decided on merit. Or their submission is to become, let them not press this. with regard to the
Look,
intervening and only
that-
by name,
yes.
only by name I will allow that and the
That
my
can,
special
that my
officer
learned
will
friends
take.
can always do, my lord, A and B. Yes, my lord.
That I do not have any objection.
Yes, then if you're telling that only on the, by name I will allow you,
By name.
and I will allow you with the supervision of the special officer, and you pay the amount to the special officer, and with regard to the municipal taxes, whatever the tax and the conservancy and all these things, you take care of it, then I will allow this.
But only one thing, my lord, this will not reduce my rights, legal rights, and as the legal heir of the deceased.
That I will not. That I will not
That is
decide
the
in this
questions to be decided
application.
at the final stage in the.
Because you have not. That's why I'm telling. If you are wanted to continue with as a legal heir, then this application is to be decided on merit.
Yes. No. Yes, my lord. And he cannot be made as party as this stage, my lord.
Yes, at
So
this stage
C
after
cannot be
5
granted.
years.
That's very good.
But I'm leaving that. I'm leaving the seat.
My lord, only two things. No right shall be created if they are running the boarding business only by name they are running.
No, that I will record
Yes,
that
yes,
only
your
for the
lordship.
purpose of
Only for the purpose of running and
purpose of
maintaining
running
my
the
lord.
business,
Not
to
creating
keep
any
the
right.
property intact. They will run
Grateful.
the business and pay the amount.
Grateful, your
One
lordship.
more thing,
Grateful.
my lord. In running the boarding house and the paying guest, no disturbance would come from the defendant.
That order of the court and the special office in presence of the special officer will there.
And my lord, one more thing, may I just clarify, my lord? Since it has been submitted, my lord, he will pay 55,000, my lord. And my lord, there are existing dues of the special officer, my lord. If your lordship for the time being kindly direct, my lord, out of that 55,000, he will take, my lord, the ongoing monthly remuneration, and my lord, the rest portion may be adjusted, my lord, in part by part against, my lord.
What is the remuneration is decided?
That was
25,000.
25,000 was decided initially. So, my lord, if he will, from the date he will, my lord, manage, he will be paying 55,000. He can, my lord, adjust, my lord, 55,000 on a current rate. The earlier, my lord, can be adjusted against the remaining part of, my lord. There will be a 30,000 proportionately from that, my lord. Then my learned friend interest can be taken care of, my lord, because he has not
When
been
you have
paid.
been appointed?
My lord, I was initially appointed in 2019, but that was, my lord, to do certain duties which I did and for which I was remunerated. But this running, my lord, monthly remuneration is payable, my lord, from 28th July onwards. So for say from August 2022, from the months of August 2022, and it's 25,500 per month.
So
I leave it to my lords, my lord. I'm not in a
5,500.
25,500 per month. It's in gold
So
mohurs.
there is roughly an 11
15
months, my lord.
1,500 GMs.
1,500.
Yes.
11 months.
So,
Roughly an 11 months, my lord.
so
If, my lord,
August
that can be, my lord.
2022.
So
And some expenses, my lord, I've incurred from my pocket, but then I don't want to claim that.
no,
It's
no,
okay.
that is to be.
It's a few thousands here and there, my lord. It's because it will take me a lot of time to dig out all the proof. That will, my lord, be.
Yes, what about your prayer? Prayer A is okay, prayer B is okay. Then
Lord, A and B possibly, my lord, he can only press.
an order
C is-
permitting the applicant to add C and D you will not press.
A and B, ma'am.
A and B. Yes, madam. Anything further?
So your lordship, only as had already been stated by the learned administrator, that he look after the any illegitimate or illegal anything is not going on for the boarding business, because we are also occupying personally as family, so the environment might get corrupted.
Counsel for the respective parties are present. Full stop London special officer is also
Your lordship,
present.
may I intervene once, my lord? I've just been instructed that certain movables are there in that portion that we are giving up, that first floor half portion. May that be taken away, my lord?
By within a week.
Within a week. Within a week.
Full stop. The three persons, namely Mayank Gupta, Mayank Gupta, Mayur Gupta, and Pankaj Gupta, son of late Srinivas Gupta, SHRINIWAS. Here is page number 2 of the GA4. Have filed the present application being GA4 of 2023, praying for permitting them to manage and operate paying guest / boarding house business from the entire third floor, half portion of the first floor and ground floor of the premises number 10 of Gupta Lane, police line station, Gupta Lane, police station, Jora Sanko, JORASANQ, Jora Sanko, Kolkata 700006 on payment of rupees 55,000 per month to the administrator pendant light, along with allied prayers. At the time of hearing of the application, on instruction, at the time of hearing of the application on instructions, the counsel for the applicants have not pressed the prayer C and D of the present application. Full stop. The administrator pendant light has filed a third report on 30th March 2023 after inspection of the premises. Wherein the description of the property has mentioned as follows. This report, third report, prayer small a, small b, small c. These are the three reports. A, B, and C of the page 2. Description of the property you mentioned. Correct. This set out.
The third report, my lord, there was a misprint. It read as second report, but then I believe your lordship made a change. So have I. Yes.
The counsel for the defendants, counsel for the plaintiff submit that he has no objection if the applicants, namely Mayank Gupta, Mayur Gupta, and Pankaj Gupta, are allowed to manage and operate the paying guest / boarding house in the said premises. Subject to the condition that they will not claim any right, title, and interest over the said premises in question. Counsel for the defendant submit that the defendants are in occupation of half portion of
Same and except, my lord, they are entitled under the law.
that I will pass. Counsel for the defendant submits that the defendants are in occupation of half portion of the ground floor,
First floor.
not ground floor.
Ground floor also.
Two
first
rooms. Two rooms.
Two rooms in the ground floor and half portion in the.
Your lordship, 3 rooms in the ground floor and half portion of first floor, my lord, is what I'm being instructed.
No. Report. There are 2 rooms. First room of the right room, ground floor, how many rooms are in the ground floor?
Look, there are 4 rooms in the ground floor, page 23 of the application.
So two rooms are with the.
Because their ground floor comprised of entrance leading to into narrow corridor with two rooms on each side of the corridor and one office premises straight ahead. The first room is the right. Yes, my lord.
Page number?
Page 23 of the application. And my lord, then my lord,
How many rooms are there?
What stated?
My lord, if your lordship take my first report,
page 23 of the application.
First report is. Sir, first report.
if your
The
lordship,
first report.
Yes, my lord. My lord will kindly, my lord has come to page 23 and paragraph 4, my lord will see the 3 rooms on the ground floor are in the possession of 1 and 2.
It is a report.
Yes, my lord. That's a report of my lord, the
inspection report.
Yes, my lord, report of the inventory of the on my lord December 2019, my lord. Of
Your lordship, what I have been
Lord.
instructed is my
16
client
December.
is occupying 2 big rooms and 1 small room.
Yes.
Office.
Of that is yes, for
That's
the
office.
office store purpose. That is for the ground floor, and the rest of the portion is be for the tenants. 2 rooms.
That's what
Yes.
I'm-
Yes.
yeah, that's what I'm-
So 2 big rooms, 1 small room. We want to clarify that.
Ground floor. It is in first floor. Ground floor কি বলছে? 2 rooms, including 1 office room in the ground floor and half portion of the first floor, and as well as half portion of the first floor.
Yes,
2
and
rooms
third
and
floor.
1 office room in the ground floor.
Yes.
And
Third floor entirely.
an
Well,
entire
yes.
third floor.
Yes.
An entire third floor. Entire third floor. Full stop. Council for the
Second floor, fourth floor for residential purpose, and this is for
fourth
the
floor
boarding
also.
purpose. Second and fourth floor, the residential purpose that is being occupied as had been stated by the learned
So that's why
administrator.
what, how many occupation?
Your lordship,
Half
ground floor,
Ground floor, 3 rooms, 2 rooms, 1 office room.
yes.
Half portion of the
First floor, then third floor, your lordship.
Second floor.
Second floor and fourth floor for residential.
Second
And the
floor,
yes.
third floor.
Third floor entirely and fourth floor residential again.
Lord, my landed friend is in possession of ground floor 2 rooms plus 1
My lord.
office, half of the my lord first floor, second, third, fourth entirety is using my lord third for business, 2 and 4 for my lord the residential. That's what it is.
The counsel for the defendants submit that the defendants are in occupation of 2 rooms
First
and
room
1
to the
office
left,
room in the
second room
ground
to the
floor,
right,
2 rooms
second room
in
to the
the
left,
first floor,
were being used as
comma,
2 rooms by the defendants.
entire second floor,
There are
third
5
floor and
two-
fourth
two
floor.
and one
Entire
floor.
second, third and fourth,
Yes.
out of which third and and
Second-
fourth your residence.
Second and fourth,
Second and
Out of which second floor and third floor,
fourth
that
floor, my lord.
second floor and fourth floor, the defendants are using for their residential purpose. Full stop. Counsel for the defendant submits, counsel for the defendant on instructions submits that the defendants are ready to vacate the total second floor.
Third floor. Third floor and half of first floor.
Total third floor and half of the second floor, out of the half of the first floor, and will hand over to the petition applicant hearing for running their boarding purpose. The counsel for the defendant submits that as there are some articles are lying in the said rooms, they require 1 week time to clear the said articles from the said portion of the property and handing over the said property to the applicants of the present application. Full stop. So, counsel for the applicants herein submits that if the first floor and the second floors have been handed, first floor and the third floor is handed over to the applicants, comma, the applicants will run their boarding business in the said premises and shall pay rupees 55,000 per month to the administrator pendant light to the state.
To the estate.
To the state. Full stop. The counsel for the applicants further submit that they will pay the taxes, municipal taxes and electrical charges and all other taxes which is required to be paid with respect of the first floor and the third floor, in which they will run the business of boarding and lodging regularly without any default. Without any default and regularly per month to the concerned authorities. Full stop. The counsel for the defendants submits that the defendants shall pay the municipal taxes, electrical charges, or any other taxes with respect of their portion in the ground floor, with respect of the ground floor, with respect of the 2 rooms and 1 office room in the ground floor, and entire second floor and the 4th floor to the concerned authorities without any fault, and also shall maintain the said building in good condition. Full stop. Consider the submission made by the respective parties, that the defendants are directed to vacate the half portion of the first floor and the entire first floor and entire third floor, and to hand over the possession of the same to the applicants herein within a week from date. Full stop. After taking possession of the said premises by the applicants, the applicants are at liberty to run their boarding business in the said premises with the intimation to the administrative pendant light, and shall pay rupees 55,000 per month with respect of the said premises to the state.
My lord, first of October, my lord, because with effect from 1st October, your lordship.
1st September.
My lord, this needs some maintenance, preparation of the boarding, rates and these all things have to be prepared there.
Today we are on 8. You will get to 20 days. They will vacate by 1 week.
They are vacating their entire things. Now we have to prepare the beds and these all things are to be prepared there, my lord. This will need some time, my lord. At least, but this will 1st October. This will need some time, my lord.
Kindly, Your Lordship, this
Because
will not take
this
that
is
long.
The court has become a business place.
These are all 40-50 beds are to be ready. These tables are made ready. Kitchens to be made ready.
Counsel for the petition submit that as the applicants, not petition. Counsel for the applicant submit that they need some time to make necessary arrangement for running the boarding business, and as such they will start payment of the amount of rupees 55,000 from the month of October 2023. Full stop.
Whenever it comes, it comes.
The applicants are directed to pay the said amount on or before 7th of each month to the administrator pendant light, and the administrator pendant light is at liberty to open the account.
My lord, your lordship may in fact direct State Bank of India High Court branch
In the State Bank of India High Court branch,
in the name of the
the name of the
estate of late Hari Pyari Devi.
estate of late Hari 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 Pyari Devi, wife of late Sitaram Gupta, resident Sitaram Gupta. Full stop.
And my lord, that the bank would act on a server copy of the
And
order.
shall operate the said bank account till he is released from this case as administrator pendant light. He is released from this case as administrator pendant light. Full stop. Who is branch manager?
The branch manager.
The branch manager, State Bank of India, Calcutta High Court branch, is directed to allow the administrative pendant light to open the account in the name of
the DC in the name of the state Haripriya Devi and to operate the same
My lord, branch manager slash chief manager.
slash chief manager, branch manager slash chief manager, State Bank of India. Okay.
My lord, your lordship would also kindly clarify that my remuneration, my lord, would come from that account.
I will come. The full stop. Initially, this court has fixed the remuneration of the administrator pendant light as rupees 225,500 per month. Rupees 25,500 per month, but due to non-availability of the fund, the said amount was not paid to the learner administrator pendant light, comma, the arrears from the August 2022
yes
till date shall be adjusted from the amount deposited paid by the from the amount received from the applicants, being the rent of the premises in question as agreed by the applicant, and from the month of October 2023 the remuneration of the administrator pendant light shall be rupees 30,000 per month, and the said amount shall be deducted from the amount paid by the applicants to the
Your lordship, lastly, your lordship, there are no borders as on date, my lord. We had made that submission to the administrator pendently during that.
that it is made clear that the applicants shall not use the said premises for any illegal activities, and all the activities shall be carried out by the applicants with the notice of the learner administrator pendant light, and shall keep the details of the borders and shall produce the same to the learner administrator pendant light as and when required.
Your lordship, there is another application, GA number 5, for discharge of the
In
administrator,
view of
my lord.
that
That
is
is
the above
discharged.
GA number 4 of 2023 is just disposed of.
My lord, one thing, my lord. Provision for the police help, my lord. Provision for the some police help is required in the case of.
I already informed to all the administrator pendant light. Why the police?
No, I don't need the police.
Yes, ma'am.
Nothing. There's no.
Yes, what?
There's no requirement for police.
For discharge of the administrator, that we are not pressing consequent to this.
What is the number?
Number 5.
Counsel for the defendant submits that the defendants have filed an application being GA 5 of 2023
Yes, sir.
for discharge of the administrator pendant light, but now they are not pressing the set. And in view of the circumstances mentioned herein above, the defendants are not intending to proceed with the said application, and accordingly GA 5 of 2023 is dismissed as not pressed.
My lord, just one small indulgence. My lord, remuneration to be adjusted, my lord, from the rent paid by the applicants and other tenants. There are and other tenants.
Yeah. The adjusted from that I will you note that I will give the learned and the administrative pendant light shall also collect the rent from the tenants of the ground floor and shall deposit the said amount in the bank.
Keep an accounts there of my lord.
I'm grateful, my lord.
Grateful. Try to I have the next matter, which perhaps will be adjourned, because
Which
this
matter?
is item number 5. The appeal is pending before the appellate court. This is in respect of I'm for the plaintiff. This is in respect of the application. The first application was for injunction and for deposit of occupational charges, where your lordship passed an order, which is under challenge before the appeal court. Now this application is for judgment upon admission, so that decree of eviction can be obtained. I believe the appeal court has passed an order where the appeal court has fixed the hearing on 16th of August 2023. We have started the hearing,
Okay.
in that
Recorded.
application. Pleadings are complete in this application, But on the
Counsel for
small
the
point of
item number,
this is 5, my lord.
item number 5. Counsel for the respective parties are present and submit that though the pleadings have been completed, but in the connected matter, an appeal is pending before the Honorable Appellate Court, and the Appellate Court has fixed the matter for further hearing on 16th August 2023. In view of the submission made by the counsel for the respective parties, let the matter appear on 4th September 2023.
Great.
Yes, fixed matter.
As for the
Chapter 13A, she had finished her arguments. I was on rebuttal.
written statement not filed. We have taken out an application after they have entered appearance. And my lord, there is an order passed by Justice Asif Chakravarti, my lord, for granting time to them to file written statement by 2nd of July 2019. No written statement. has
Well,
been
let her
filed.
not do this again.
No,
The same
I'm
thing had
sorry.
happened.
Please don't interrupt. I don't like interruption. I'm making submission to the court. You have a habit to. Lord, this is my claim that my land fund has no.
Who has filed the application? GA 105.
Chapter 13A.
Your application, chapter 13.
Yes.
Yes. So your submission is over.
Her submission is over.
I have argued before your lordship on the last occasion, and my lord, my amount that has been paid is admitted. A story that has been made out by them is this, that it was given to be adjusted from the amount allegedly due and payable by the father of.
Correct, correct.
This is the story.
Check letter and all these things, confirmation. Yes.
Check. Original side rule.
Check has not been returned. They have, we have given.
Original side rule.
My lord, I have also cited one judgment. You don't mind asking? 5 principles.
Have you given the judgment?
Yes, my lord. I can give another copy. I've got.
Yes. Kirnamai. Yes.
আমার কোনো নোট কিছু নেই কেন বলতো? এটা কি অ্যাপ্লিকেশনটা? সেটা আমাদের, চাকরিটা আমাদের। আমার নোট ছিল। Ma'am, not the suit is on the basis of a check. The story is, if your lordship has a look at the application once, paragraph 4. On 15 June 2015, the defendant respondent approached the father of the plaintiff, Shiv Kumar Agarwal, for grant of temporary accommodation loan for a sum of rupees 10 lakhs and assured that he would pay the sum of rupees 10 lakhs with interest on demand. In view of the long-standing relation acquaintance, plaintiff's father with defendant agreed. So they gave me a loan. So it's recovery of money advanced by way of a loan. 10 lakhs was the loan. She has, or the plaintiff has paid that money to me. And then there are no correspondence. Then there is one letter by which they have asked for that money to be refunded. That is that letter. Not, I'll show that to your lordship. Original side rule there, sir. Original side rule sana. 21st July 2017. There is a letter saying that I have given you loan, you have not. So first they file on order 37. There's a summary suit that they file that gets converted to a regular suit because this was on the basis of a check, and we showed that this does not come under the category of a summary suit because on the basis of a check, therefore it can't be. It gets converted into a summary suit. Then they come up with a chapter 30. Lord, my argument has been advanced, the check given, no defense. Money has been lent in advance, it's not been repaid. Therefore, there can't be any defense. You go ahead and pass chapter 13A, pass the decree. Lord, in my respectful submission, the most important aspect of chapter 13A has not been fulfilled. Because the story is that I had approached the father of the plaintiff to get a loan. The loan comes to me by way of a check from the plaintiff to me. So the first thing disregards my defense. I'll come to that later. First thing that they'll have to show, come by way of an chapter 13A. So she will have a look at chapter 13A once. Internet. Pleasure. 13A. Sorry, Mother, I don't have a copy of the rules right now.
Take this.
No. If I ask her, she'll scold me. I'll just take it up from the net. Give me a minute. Just bear with me for a minute. I'm sorry. Lord, if I remember correctly, the opening words, Your Lordship will find that there has to be a relationship. A jural relationship will have to be established between the plaintiff and the defendant. Lord, on that count, could I just, Lord, I'm sorry. Yes. The provisions of this chapter shall not be applicable save to suits in which the plaintiff seeks to recover a debt or a liquidated demand in money payable by the defendant with or without interest. Well, this on a contract express or implied. This not on I, and 4 is not the case.
Yes.
B is also absolutely so not a case of. So this, the first hurdle that the plaintiff would have to cross is that there exists a contract. Please. I'm grateful to your Lordship. There exists a contract that is express or implied.
Yes.
Lord, issuance of a check does not have any such presumption apropos existence of a contract between the plaintiff and the defendant, either express or implied. On this, I'm protected by a judgment. I'll cite that. Because this is not a case, Lord, where 139 of the Negotiable Instruments Act, the presumption can be drawn.
Yes.
Because this is not a case where I have issued the check, that there'll be a presumption of debt.
Correct.
A check can be issued, and as have been held by your Lordships, for myriad reasons. Under several circumstances. Now, with regard to, because your Lordship is now looking at the evidence, in a way that evidence will not be required at all in the suit. That is the purport of chapter 13A. So now your Lordship is looking at facts where X has approached Y's father for grant of loan. Y has issued a check. Then Y has not produced a single document apart from a letter which is issued after 2.5 years. Y claims to have been entitled to, the plaintiff claims to be entitled to interest of 18% per annum. There is no demand of that interest. There is no repayment of that interest. There are no ledgers, no balance sheet, nothing disclosed of the plaintiff. Disregards the defendant here. The ledger of the plaintiff was showing that this is, I am a debtor, where this interest is being shown in the balance sheet. For anybody who's done commercial litigation, your Lordship is in this determination today. These balance sheets come before the court. If X owes Y money, then why produces on record documents apart from just one letter demanding money in 2.5 years? So first part of the story, the check was given as a loan. I'm doubting that. I am saying there was no loan at all, and I'll be able to show that. But this introduction of the plaintiff's father is not by me, it's by the plaintiff. My specific defense is everything was done pursuant to a negotiation that had happened, where I sit in a gaddi in Barabazar. I was to purchase certain amount of quantity of goods and give it to this plaintiff's father, because he's also into this business from what is my understanding. If he's put in the box, I'll be able to get that out. He gets into a negotiation with Y to purchase certain amount of dal at a particular rate. I facilitated the entire transaction. I am supposed to get this as a commission, which is HON pays to me. So this money that has been paid to me arises out of a commission that I'm supposed to get, which again, part payment I have made to a third party. That document is with me. I had on the last occasion said that if your lordship allows me to just place it, I'll be able to place that document. If the plaintiff insists, I'll file a supplementary affidavit. But my bank statement is there indicating payments being made on that day to the third party elsewhere. Now, but I'll come to my defense later, whether it's moonshine, whether it's plausible. But I am firstly trying to attack this application on the ground that the basic requirement of Chapter 13A to show that there is an existence of a contract is missing. Because my learned friend should have addressed this issue to your lordship, that issuance of a check creates a contract between the parties. Because a check can be issued for any reason. I can have a contract with your lordship. This check can come by way of security for that. X can have a contract with the plaintiff. The check can be issued by the plaintiff for that. Check can be issued for security. Check can be issued for payments made on behalf of somebody else. Check can be issued for a loan. When all these three possibilities are available, then first hurdle that they'll have to show is issuance of a check creates a contract. My first respectful submission is issuance of a check creates no such presumption. In aid of that, your lordship will allow me to cite a judgment. This is reported in 2010, SCC Online, Karnataka, page 54. बोलले तो अपने रेगे जावे था.
Why? If you don't want to give citation, please don't. I take from my book.
কেন রেগে যান মঞ্জুরি এই নিন.
I don't like this way of your.
এই তো কপি দিচ্ছি. আরে
You can't talk properly, don't talk.
কি অদ্ভুত. 2000 কেন এত unnecessarily আমাকে 2000 আরে কপি দিয়ে দিয়েছি আমি. 2010 oh 2010 SCC Online, Karnataka, page 54. Look, paragraph 8, your lordship will see. Well, this is with regard to 139, where the presumption requirement apropos check. Your lordship will just turn it over, Milord. From line about 5 from top, it is highly unnatural. May I, Milord?
Yes.
It is highly unnatural that the complainant, for the purpose of lending substantial sum of rupees 50,000 to the accused, would borrow the same from others. No documentary evidence is produced by the complainant to show that she had borrowed money from the Credit Cooperative Society and others. Admittedly, the accused had no financial capacity to 50,000, nor he had any savings. In the absence of any evidence placed by the complainant, it is highly difficult to believe that he had borrowed money from a credit cooperative society and others for the purpose of lending the loan to the accused. In addition to this, kindly mark this, Manoj. In addition to this, except the check in question, there is no other documentary evidence to show that the complainant had lent rupees 50,000 to the accused and the accused and acknowledged the receipt of the same. No contemporary documents have come into existence. When a substantial amount of rupees 50,000 was lent, it is reasonable to expect that the creditor would insist on the debtor to execute some document evidencing such transaction. Absence of any such documentary evidence would create great amount of doubt about the genuineness of the transaction. Section 269 SS of the Income Tax Act of 61 insists that all transactions involving 20,000 above should be through account paid checks. It is not the case of the complainant that the loan amount was paid by way of an account paid check and that there is a violation of the Income Tax Act. This, there is no material on record to show that there was an arrangement for payment of interest. If the complainant had lent rupees 50,000 by borrowing the same from other sources under normal circumstances, there would certainly be an agreement for payment of interest between the accused and the complainant. There is absolutely no evidence on record in this regard. Absence of any such agreement for payment of interest between them also would create great amount of doubt about the transaction. All these circumstances go ahead to produce this.
Yes. Yes.
No, so except this check, there is nothing there. Now to suddenly now presuppose in a chapter 13A that this check was for a loan and that there was creation of a contract between me and her with no other documents is possibly something that the plaintiff or this applicant has not been able to establish. With regard to how her Order 37 suit got converted into a regular suit, certain things, if your lordship could kindly see, there's an observation which is there, my lord. If your lordship could just have a look at. না এখানে লাগাই তোরা ছিল যেন only to highlight this, that this honorable court has held that order 37 could not have lordship will have a look at that order. This was heard order 37.
Yes. It is there, page 14 of the print.
It is there. She has annexed that.
Page 14 of the.
I had also seen it. But if I could just place that part of the order. Yes.
Page 14 of the
Yes,
print,
my lord,
last paragraph.
But one paragraph, if I could just.
Yes, which paragraph you relied upon?
Lord, paragraph 14, page 14, my lord. There is no way.
Check may constitute the mode of payment by the printer.
No, submission. Well, there also we had taken this plea. Your lordship has seen at page 14, clause A of rule 2 of chapter 37 of the code provides that a plaintiff may file a summary suit against the defendant when the suit is upon bills of exchange, hundis and promissory notes. There cannot be any doubt that a check is a bill of exchange within the meaning of the term of negotiable instrument act. Mere issuance of a check by the plaintiff in favor of the defendant for advancing a loan to him cannot bring a suit within the categories specified under clause A of rule 2 of chapter 37 of the code. Checks may constitute the mode for payment by the plaintiff, and they may constitute the evidence of transaction of the loan, but they cannot be said to be the basis of the suit. Therefore, in the present case, the mere fact that the plaintiff lent and advanced the alleged loan of rupees 10 lakh to defendant by issuing a check does not constitute a ground for filing a summary suit under chapter 37 of the code. Now, this is the same, the goose as the gander, my lord. Because the reason why her chapter 37 does not survive is the check could not have been the only basis of the suit. There was no contract which was express or implied. And unless the plaintiff established that contract on the basis of a check to come under A2 of chapter 30, order 37, this court has held is not possible. The same test apropos A in my respectful submission will apply. Because simpliciter the check can't be the basis for the same reason that her order 37 failed. Yes. Because she will have to get into a box and prove this. If your lordship now takes up, my lord, paragraph 4, what I had placed.
Yes.
Paragraph 4 of the chapter 13 application.
Yes.
Look, on or about June 2015, the defendant respondent approached the father of the plaintiff, Shiv Kumar Agarwal, for grant of temporary accommodation loan for a sum of 10 lakhs and assured that he would repay the sum of 10 lakhs with interest. This has been affirmed at paragraph 19 at page 8, as something that is true to her knowledge. So it's a verbal agreement that is the substratum of the suit. The check is an aid of that agreement. This is how the order 37 also failed. So if she can't prove this agreement, oral agreement, by linking paragraph 4 to the issuance of the check simpliciter can't be the basis.
Yes.
I am not even on my defense. I'm saying that even tomorrow I'll come up with another chapter. Somebody will come up with a chapter 13 before your lordship. So in a verbal agreement, especially when there are no documents, where you plead that the verbal agreement was, I will repay you on demand at 18% per annum, and your written demand is not within the first financial year, then how have you capitalized or what have you done with that interest in your books if it was actually payable? Why isn't there any sort of agreement between me and you and no letter, no demand? One letter comes after 2.5 years. I have not replied to it. Me not replying to that does not give her the exalted status of being able to avoid the docs and prove this. So first is not, unless paragraph 4 gets proved.
Yes.
There is, the check is to be linked to paragraph 4. Check by itself can't form the basis.
Yes.
Now this that I'm arguing is now decided in that order 37 application.
Only check.
Oh, that's right, Manoj. Now, with regard to my defense, detailed figure-wise, I have been able to produce here how and what money I had traded on behalf of the father of the plaintiff. And it's written also. And the averments in the reply to it is this is a product of cunning drafting. Till clever drafting, we've had Justice Rumapal say, but cunning drafting in an affidavit, that have not really come across.
Art
But-
of drafting.
Art, art of clever draft. Yes, till that much is fine. But to have a draft being called cunning, well, I'll take that. But we have been able to show the percentage that I was supposed to get. How much money was the entire transaction for? The plaintiffs very upset that I have roped in the father in this affidavit in opposition, saying that this is a completely cock and bull story. But I just want to remind the plaintiff that I have not brought the plaintiff's father. It is the plaintiff who has brought the father into the question by paragraph 4. And there is a reason for that. The reason is that there was a very long-standing acquaintance that I was with the plaintiff's father. That is an admitted position. There is a transaction that has happened pursuant to which I have paid that other trader. Your document rakha? But on that date, one thing is to make up a story. Other thing is to make up a story to have the letter, that check date, and payments made to third parties of that particular amount to match. That will be that will really cunning drafting. I can't be. This is the original bank statement. If my learned friend insists, I'll bring it by way of a supplementary affidavit.
Seek to filing of any document at this stage.
Okay, okay.
Application was
Okay,
filed
okay,
in
okay.
the year 2020.
So I don't want it at
Yes.
this stage. I want to put them in the box.
So, yes, you
So,
succeed
very well.
whatever you have in your affidavit.
Yes, tell me.
I'll just.
My lord, I have not seen the practice of ending documents from law.
कौन figure था देखो तो?
The other matters are released.
My lord, only item number 8. That's some
Then wait.
Check check
Because I would have mentioned before lordship at the time of rising.
Here your lordship will find an
My
entry.
lord, sir, my learned friend is arguing from a document tendered from the bar.
Lordship will give it back. Let it be.
Not my learned friend can
No, you
rely
take-
Very well,
take
my
the
lord.
copy.
Lordship will give it. No, I'll give it back.
Not my learned
Let
friend
it be.
cannot rely upon.
Let it be.
If he argues, my lord, I can.
Okay, okay.
Let it be. I don't want to embarrass the bench. No, leave it. Let it be. मत करो ऐसा। लॉजिक जो मैं embarrassing मत करो। बुझो।
Yes, next.
Lord, kindly have a look at my paragraph G onwards. First, I have denied any such agreement, verbal. Paragraph G onwards, your lordship will see. F, sorry. E, sorry, my lord, E, sorry. Sometime in May 2015, Shiv Kumar Agarwal had approached the respondent for purchase of 300 metric tons of mott dal. The respondent, however, did not have the requisite stock at the relevant point of time. Shiv Kumar Agarwal had evinced interest to purchase a requisite quantity of pulses at the existing market rate. The respondent, in the usual course of business, had the knowledge of a third-party trader who at the relevant point of time had the requisite quantity of pulses. The respondent introduced Shiv Kumar Agarwal with Shri Parasnath Industries of Nokha in Rajasthan. But why this is being resisted is I'll be able to show payments in the bank statement made to this Parasnath Industries. The respondent proposed that Shri Parasnath could sell the goods of requisite quantity in favor of Shiv Kumar. The respondent further proposed that the goods to be sold to Shiv Kumar Agarwal at a price marginally lower than the market price at the prevalent point of time. Due to the intervention of the respondent, Shiv Kumar Agarwal could get an offer to purchase 300 metric tons of quantity of dal from Parasnath Industries at a price of 90,000 rupees per metric ton. No, this is figure date-wise we've given. Although the prevalent rate at the market point was substantially higher. It was agreed by and between Shiv Kumar Agarwal and the respondent. The respondent shall introduce the Shiv Kumar said Agarwal to Parasnath to facilitate or broker the purchase of requisite quantity of goods at a rate as stated above. It was further agreed by and between Shiv Kumar Agarwal and the respondent. The respondent shall be entitled to brokerage or commission of 2% of the total value of the transaction. This was the agreement between the parties. The parties have been ad idem on such issue and have proceeded on such basis. Lordship stops here. Lord, my case is this money I have received towards commission. In fact, this was also towards reimbursement that I have had to make to Parasnath. That entry is here. I don't want to embarrass the bench for not by trying to force into a document which is being registered, but I have that bank statement which shows payment has been made. So on one hand, your lordship has a verbal agreement with one check, calling it a loan given at 18% per annum, no other documents, ledgers, balance sheet, nothing except a loan recall, apparent loan recall notice. On the other hand, I am saying that this was a complete transaction that had happened. And this was a commission that I had received. Now, in chapter 13a, then what is the test? Well, in this context, allow me to rely on judgment passed by my lord. Judgment now. Then what does the court do? Because recent Supreme Court judgments your lordship has considered that refusing to grant leave is the aberration. That is the exception, because a party is being shut out. I can put Shiv Kumar Agarwal in the box and have this transaction. Exactly, because she will also have to do that. To prove her paragraph 4, to link that to the check, because her case is also a verbal agreement.
Because only in the original side, chartered court has some benefit. Otherwise, if you go to the regular suit, it's very difficult.
But this is the commercial, no?
No,
It's commercial.
That's why. Otherwise, it is very difficult.
No, I don't mind this because
Yes. Which paragraph you are relying upon?
well, this is 2022 SCC Online Calcutta 2323. Well, first line. The plaintiff has filed the suit praying for a decree of rupees 72,67,390 along with interest and further interest. So suit for recovery of money. Disregards the rest of it, my lord. Your lordship considers chapter 13a. And then, my lord, this I would have cited separately. I'm not going to trouble your lordship. At paragraph 8, your lordship has referred to a judgment of 2017 1 SCC.
Yes. 37.
Yes, my lord. Paragraph 10. Sorry, 9. As per record of the instant case, the defendant has not filed in written statement. It also appears from record that since for the long time the defendant is not appearing in the suit, defendant had served the copy of the affidavit in opposition to the counsel for the plaintiff, but the same was not filed in the department and the said affidavit in opposition is not available in the case record. Copy of the affidavit in opposition is supplied by the counsel for the petitioner to this court at the time of hearing of the instant application. Pauses here for a moment. This is a case where your lordship is hearing, and forgives me, but this is what justice is. The party is also not before the court. The affidavit is not in the department. Your lordship looks at it to examine if there is a plausible defense or not. That is the only inquiry, and the court does that. In the affidavit in opposition filed by the defendant has admitted that the defendant had approached the plaintiff for financial accommodation of rupees 50 lakhs for his business, but had denied the interest of 9% per annum. Kindly mark the next line, my lord. The defendant had also admitted that a check is given to the plaintiff for security. The defendant has admitted by way of his acknowledgement dated 30th March that the defendant had received an amount of 50 lakhs by RTGS as loan for business purpose, and the said receipt of the defendant is duly corroborated in the bank statement of the plaintiff dated 30th March 2011. The defendant has taken the plea that by a letter of 26 May 2014 had informed the plaintiff not to present the check in the bank account as due to the pressure of the bank, the defendant has closed the current account. But in spite of having the knowledge, the plaintiff has deposited the check on 27 March 2017. The defendant has also stated that the plaintiff has lastly made the payment in the month of January 2012, specifying the entire payment is to be made by the petitioner on or before 31st 12. And thereafter, no payment was made by the defendant, and the plaintiff has not taken any action within the limitation period. Though the defendant is not appearing in the suit, But in the affidavit in opposition, defendant has taken the point of limitation as per letter dated 26 May 2014. The defendant has informed the plaintiff the defendant has closed the current account and requested not to present the said check in the bank, but in the year 2017, the plaintiff had presented the said check. In the plaintiff has mentioned the date of cause of action to be 20th September 2016. That is the last date of payment of interest. But the defendant has denied with regard to the interest, and the document which the plaintiff has relied the defendant has paid the interest that is executed by the plaintiff only, and there is no evidence that the defendant has paid any interest to the plaintiff. After considering the above, the court finds the defendant has raised a triable issue with regard to the interest and the point of limitation, and the plaintiff is not entitled to get the relief as prayed for in the instant application. Chapter 13A dismissed. Why, my lord? Because of that A of contract. Unless you cross that hurdle, this judgment is exactly on that A. That is why I wanted to cite this. And here it is akin to what we have here. There it was admitted loan. Still your lordship did not give the interest, because on interest there was no express or implied contract.
Even 13A, whatever it is, once it has been found that there is some dispute and that is not on record.
Man, I'm grateful. Man, that is not on record.
But not on record.
That's not on record.
Court cannot imply it.
I'm grateful. Man. This is what I thought I'll have to labor on. This is what it is. Your lordship is right. It is, had there been a written document.
Correct.
End of story, because it would have been on record. No further evidence is required. But unless
that's why the moonshine.
That's why the moonshine. There's a document. I'm saying the document is not executed. It was, then it's moonshine. Then it's not a plausible defense, because any evidence contrary to that would be hid by 91, 92 of the evidence.
That's like a pronote.
That's right, my lord.
It's like that's why the first is the contract express.
And here, unless she links forth to the check, which she herself affirms to be true from knowledge, the court will test the veracity of that knowledge. Unless that is established, the veracity is substantiated, the check is meaningless. So on the count that her order 37 got dismissed, it suffers from the same folly here. Well, I don't think I was carrying another decision. There is a very bad point, not acronym. There's a bad point, but I'll take it because there's a lot of hostility that I face, so I'll take the bad point. Otherwise, I would not have. I'll take the bad point of Money Lenders Act. Oh, no. Very. Not required. No, because she's charged interest at 18%. Commercial.
But see, that is also dealt by your division bench also.
Yes.
Though the interest, but it is only the one transaction. One transaction. One transaction.
Not.
It will not come on.
Well, there is one more judgment of this honorable court, my lord, where similar. There was an affidavit which said that there is a dispute. Because it was there, the court said that this has been disputed. It's a plausible defense because the plaintiff is not being able to prove the basic. I'll just, well, this we've got from the server. I'll give a copy to my learned friend. It'll be easier for her. I had a copy down. No,
Actually, when this money laundering, I was new to that act.
That one?
I was new to that act because in Andaman that was not there. So first matter was I was some little bit confused. Then I researched on that. And what has happened? Well, Mr. Ritoputro, he has, in one case, he has relied upon, one case is objected for, taking into consideration.
In fact, when we were researching on that, we found your lordship's judgment on this point against me of money lenders. Because that has to be the approach. Otherwise,
this issue without long back in the year 2000. In fact, the side had taken this point because argued very vivid and it is a reported judgment.
Okay.
Yes, where is this? QQ.
My lord, here also, if your lordship looks at page 2, the last sentence, the defendant is not represented. All these matters in chapter 13A, the defendant doesn't even come
Very difficult.
to,
See,
unless you have a case like this.
undefendant suit, not appearing.
Defendant is tough.
It's very tough. Then
Undefended
the
is
court
tough.
has to take all the risk.
The defendant is not represented. However, Mr. Sengupta, learned senior counsel appearing on behalf of the plaintiff, learned counsel appearing on behalf of the plaintiff, has produced before this court a copy of the affidavit in opposition filed on behalf of the defendant. Now, the affidavit is fully set out and looked into, Milan. Just one thing that I wanted to point out. At 5. In a summary proceeding, the court decides the matter on the basis of the affidavit evidence. In the affidavit in opposition, the defendant has stated that although the goods were of agreed specification and were in a deliverable state, the plaintiff has failed to take delivery of the goods because of decline in prices, and instead had demanded return of 1 crore allegedly on account of failure of consideration. Since the goods has been manufactured and were in a deliverable state, the defendant has stated plaintiff is not entitled to any claim. In an application of this nature, the court is to be required to be satisfied that the defense discloses either moonshine or so improbable that ultimately the defense would not succeed. Even if there is a very weak defense, the court normally would allow the defendant to defend the suit on conditions. Although it does not appear from the record that the defendant in fact had manufactured 300 metric tons and the said goods were in a deliverable condition, since there is an averment to that effect, and in the event the defendant is able to establish that at the trial, that in spite of the fact that the goods were manufactured and were deliverable condition, and the plaintiff had refused to take delivery of the said goods due to decline in prices, then the plaintiff might not ultimately succeed at the trial. Accepting the contention of the plaintiff as sacrosanct would be prejudging the issue. Moreover, the defendant has alleged in their communication so-and-so these correspondence prior to, and this application for summary judgment was dismissed.
Yes.
But I'll not burden your lordship with any more. Well, there is, Supreme Court latest. But there's this recent Supreme Court judgment that I came across. Well, lordship will give me 20 more seconds.
Yes.
20 more seconds. The Supreme Court judgment. 2023. Well, I am not distinguishing the Dasi judgment anymore, because this has been considered in the 2022 3 SCC 294. Your lordship will find 20 copy diye dao na Manju. Here your lordship will find that leave to defend is the norm. Denial of that is the aberration.
Correct.
Anyways, I think we'll have to trouble your lordship on another day, because my learned friend will deal with this in reply. I'll just indicate this judgment on that day. But 5 minutes and not more. No?
Counsel for the respective parties are present. Counsel for the defendant has argued at length, but due to paucity of time, argument could not be completed. Fix 6 September. Not
My lord, it will be very long because that is almost our good.
there is a one 18th August. What time? 18th August 2 p.m.
Great.
My lord, may I just say one thing? Lord, I have objected to the document being handed over from the bar. If my learned friend had in possession the document that was available with my learned friend at the time of filing affidavit in opposition.
Okay.
4 years have gone. You could have
Okay, you
used
come,
it.
you come and reply.
One can
No, I'm not relied on it.
It's not relying on.
I'm not relying on it.
You could have done so, my lord.
No,
I'm
let.
otherwise, I'm not averse to
Okay.
the document being filed.
Yes. Yes, what matter?
That matter, trust matter.
Which one?
No other side.
Which one?
When my lord had allowed the sale of the property at 20 lakhs per kata. Money has come. KMC dues has been paid. Now, the entire money is lying with the PNB, High Court branch. My lord, 7 crores and all. We have taken out an application. Everything is done. only to Millet transfer the money from this account, because this was done for the receiver's account for the entire conveyance and all those things, to the account of the trust, and Millet receiver may be released. This is the applicant, because the Millet the remuneration for this month is already due of the teachers and non-teaching staffs. Millet, I am facing that hit Millet from the school.
Which application?
Item number 8, Millet, there is no other side, there is no difficulty. All the trustees are before your lordship.
Keep tomorrow as to be met.
Paying for me, this is number, I am only paying for 5 minutes of lordship time. Millet, any time Millet can you fix 110?
That's
Millet, yes, Millet, because Millet, 5 minutes before Millet recess.
1 p.m. Come tomorrow at 1 p.m.
I will take 5 minutes. I will not consume with 1:05. I will Millet sleep.
Okay.
Okay.